Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
Is the next search on February 28, 2020? 7:44 p.m. How, period, does the FBI find people? And people is misspelled P-E-O-O-P-L-E. Did the defendant find out how the FBI finds people in this case? Oh, she found out.
All right. We are back. We're back from lunch. I don't know if it's a lack of sleep or it's probably lack of sleep. Let's call it that. The 4 hours I got last night were not quite enough. I'm still not quite calmed down. My watch tells me that the alarm went off and told me that my heart rate was over 110, and it did not appear that I was exercising. I was a little bit riled up, apparently, so I apologize. I let my emotions carry me away just a little bit. That was a very difficult thing for me to sit through. I had a hard time staying completely objective during that, so I apologize for that. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here this afternoon. Thank you, all you wonderful people for being here. Thank you. Especially a big thank you goes out to, let's see, who would it be? I think it's Kim. Why is it not working now? Oh, it helps if I click on the button, huh? It's my fault. Operator error. There we go. Kim R. You were, this is impressive, because even though there were a lot of people in the running, you were both first and second in chat, which says something. It really does. It means you're definitely the winner. Congratulations. You've won before. You're a repeat offender, habitual offender, if we say so ourselves. You've won the chat many times, and as a result, you have been penalized with owning the internet many times as well. But I will say that every time you did carry that penalty, you did so admirably. So it is once again your responsibility to own the internet and maintain everything to which it is connected. So good luck with that, Kim. Thank you very much for being first in chat. I appreciate you being a supporter of the program. Okay. Let's see. I'm only human. I apologize. I try very hard to remain fairly neutral and open-minded through trial. Right up until, that's why we don't do polls in trials as far as where everyone's leaning until the jury's heard all the evidence, until they've heard both, either the prosecution and defense or the plaintiff and the defense as it goes in a civil suit, and that got the best of me there. We are, however, going to move on from there. Politiquips. Why didn't the plaintiff go harder on Smith? She ended up looking quite reasonable. I don't know exactly. Jules sent me a text and said, hey, lots of things happened in the background that, we'll have to talk about that, sorry, I couldn't call. There was lots going on. I don't know. I don't know exactly what was happening. We did hear from Jules today. She's there in the courtroom. I think we'll see her there again. Let me make sure we've got audio turned on properly. Let me, let's see. There we go. So we do have that up there. We are... Let's see, where are we at? Let's see. First of all, Peter Steele, can you send me a text on the burner phone? Can you do that? I think the burner phone is active right now. If you type !burner in chat, I would appreciate that. I just need to get something over to you really quickly, if that's okay. Let's see. Lynn says, I don't think she looked reasonable. She looked evasive and egotistical. I struggled with that testimony. I struggled on direct. On direct, I struggled because he just did. Wonderful. Okay, we'll get this squared away right now. Sorry, just doing some stuff in the background here. I struggled with that testimony. On direct, everything she did was right. I bristled just a little bit when I heard that she doesn't look for the good things. She only looks for evidence of child abuse. She's literally looking for something to confirm her suspicion. Every time she goes in, she's looking to confirm her suspicion or confirm someone else's suspicion. And completely discounting and I would say ignoring evidence to the contrary that would say this isn't what it may appear from one perspective. And then putting that all on the family and saying, well, if they want to fight it in court, they can before the judge. They can get their own evidence and counter, for their side. Because I'm on the side of finding the evidence. That's my job. I struggled with that whole approach. Rhodey says, I thought she did well. I think she did as far as her beliefs. If you agree with what she did, and that's perfectly okay to do so. I'm not saying that's wrong. I personally struggle with that.
I've been helping to fight DCFCPS for years, and she is at epitome of pure root evil.
Okay, so I won't say she's the epitome of pure evil, but I struggled with her approach. I struggled with how that matches up with the bigger picture of caring for the patient, caring for the child, do no harm. It just seemed like the goal for her seemed to be different than what I felt would be right in that situation. Now, there are situations where we need people like her, that it's very necessary what they do. But why would you not weigh all the evidence? Why would you not present all the evidence in your report? It is as a report. Here is what I found. Man, it's frustrating me. It's really bad. I can't wait to hear a couple other opinions on this because I'm still in my head. I'm trying to put together in words the big feelings I have. And we tell our little kids, use your words. Use your words. Tell us how you feel. I'm speechless. I don't have the words to tell you how I feel and why I'm so upset about that. So I'm going to just calm down. I'm just going to take a break and move on as I throw my gavel across the desk. Sorry about that, computer. All right. Let's see. We've got a few things we need to bring up. First of all, the objections. Let's bring those up on the screen. Okay, we're up to 1,433 on the objections when it comes to, to power on my other device. There we go. When it comes to our guesses, as we take a look at this, let's scroll down through the guesses to 1,433 and see who's currently winning the guess count. 1,200s, 1,300s, 1,400. There we go. 1,432. Roro, we just passed you. Debbie Blair as well. Maisla is currently winning. Listen to Learn is coming up at 14:35, and Tish Doran is next after that. I'll play this just for a little bit so you can see who's coming. Then we'll take this off the screen during trial because it's a little distracting. Anyway, I was saying if you agree with what she did, the action she took, I can see why you would say that was very good testimony before the jury, and I'll give her that. She testified well in front of the jury. She knew her facts. She stuck to them. She was not cornered into by any questions by Mr. Anderson. There were no gotcha moments. I would say she was a good witness. I wouldn't say stellar, but she was a good witness. But for those that saw that in front of the jury and say she did a good job, how do you feel about how she behaved, or how do you feel about the exchange? I guess you should say. I'm not going to try to attack her behavior because she was being attacked by Mr. Anderson. How do you feel about that exchange? How do you feel about the proffer that happened afterwards? Is there any concern there for you there? That's just my question. We do need abuse specialists, but holding dual privileges at the hospital muddied the waters. 2 chains of command. And the problem is when you have access on both sides, there is no check or balance. You are both parts. You're both parties. Yes, the court has authority to issue subpoena and force the company to
A child in
divulge
care
something.
in the hospital brings big $sign. A hospital billing coding for CRPS brings in huge $sign. Maya was a moneymaker.
I don't think the plaintiff is raising that as any of their complaints. Even when it comes to the fraud, the billing fraud, I don't think they're addressing that. But there's no doubt that it can make a lot of money. A hospital can bill a lot for some treatments for some illnesses. So that might have been a factor of why the billing was done the way it was. Stephen, you missed the proffer. Oh man. You need to get some comfortable clothes, sit down, be relaxed, get a comfy beverage, and maybe a cat to pet, and then you can watch the proffer. It was rough for me. I struggled with that. Lynn says, I thought she was unethical before proffer. After proffer, I thought she was deliberately cruel. I don't know. I've got to wait. I've got to take a step back. You know how the judge is really good at this when he gets riled up. Okay, I'm going to take the guesses off the screen. That shows you what's coming up in the near future. But there we go. When the judge gets riled up and he gets angry at a lawyer or something, he's like, I'm going to take a 5-minute break, and he walks out, and in those 5 minutes, he's able to zen, just find his center again. He comes back and he's like, all right, where were we? I'm not to that point yet, and I probably need to stop talking about that until I can have a zen moment, think it through a little bit better, and then I'll probably share my opinion at a later point. Kidda Smith says, I was so disgusted by her answers and how she was acting. To me, that is just evil. She's evil in my book. You know, we call ourselves the court of public opinion, but we sit here and watch trial and imagine that we are in some way representing the jury, or that we're very similar in some ways to the jury. That's why when we do a poll, we think, hey, what if the jury comes out with a similar type of results as we do? I've got to imagine at this point that members of the jury maybe would relate to many of these comments that say, this is too much. This is a bridge too far. I don't know what's the statement there, or the saying. Power without oversight is a recipe for problems. I'll say, right? Problems for sure. Let's focus on what's next today. Kel and Jane, I agree with that. Let's move forward from this. I think we have a depo to be played. I know we've had a couple depositions that still have to be played. The plaintiff team has really cut back what their designations are in these depositions. So the depots are really cut up. They're chopped into pieces as both sides are sort of conserving time, and so we have really chopped up depots. We have one deposition that we've heard part of twice, and we're still expected to hear the third part soon. It was 2 hours. It was cut down to 1 hour. That we got a few minutes into, and once again, it was stopped, and we imagine that that's going to be played at one point today or very soon as well. I was enjoying seeing the guesses. I could put them back up. I think that's where we left off. It's we'll have to go a little faster than this. Let me put it on. Let's see, I think it's this one. There we go. Okay, I'm going to scroll them a little faster. This is my teleprompter that I use for this. I don't use a teleprompter for any of my live streams. I speak off the cuff, as you guys know, and usually mispronounce everything at the same time. But I have a device that works as a teleprompter, and I use it for this. It's also my slow motion replay machine. When is Miss Beatty testifying? Linda, Miss Beatty is scheduled for Monday, and that is right at the end. We've got Jules on the phone right now. Hold on just 1 second.
Jules.
Hey, Jules, are you with us?
Yeah, I'm with you.
Wonderful, wonderful.
Okay, so listen, this is what happened. John Stewart, I think I've spoken to you about him before. He is one of the survivors of Sally Smith, okay? Mm-hmm. His child was taken away due to false child abuse accusations, and he did time in jail because of her. He is also part of the Netflix documentary.
Okay.
Well, he confronted her outside.
Oh my goodness.
It was bad. It was really, really bad.
Was it pre-testimony or post?
Yes, it was pre-testimony. And, while he walked right up to her and he said, Sally Smith, and she's like, who's asking? And he said, what, you don't remember me? I'm John. And soon as he said John, she turned around, walked away, and he went off. He went off so bad that you heard him on the second floor of the courthouse. Okay? And then the deputies came out. And then she was escorted in. And then it was, normally we have two deputies in the courtroom, one on each side of the front of the courtroom, on each side of the judge. Well, after this whole thing between John and Sally Smith, and they brought in 3 more deputies at the back of the courtroom. And I'm right, it was not good. And so he went off. So 2 deputies came outside, and John went over to the assembly area with his signs and all of this stuff. And then he told one of the deputies his story, and he demanded to know, why has she not been arrested? Why has she not been arrested? I mean, Scott, it was just unreal. So the one deputy took down all of the information from John, but another deputy came out and said, Mr. Stewart, and he looked at him and he goes, how do you know my name? He goes, it doesn't matter. But you either have to calm down. We can't let you back in unless you calm down. And so John said, you know what? I'm leaving. I'm good. I'm leaving. I did what I need to do. And now he is going to her place of business and he's protesting there. Yeah, he's upset. The man did 8 months in jail for a crime he did not commit. So there's that. The jury was very stoic today. They were not as animated as they usually are. Yeah, I mean, I was a little surprised on that. Their questions were good. I was a little bit upset at the fact, though, that the judge did not read all of them in.
Right.
And that proffer after.
Yes, the proffer.
Okay. The proffer after, Hunter wanted that on record because they are filing for appeal. They know this. They know they lost the case. They know they did.
Wow. Yeah, I struggled that proffer. I lost my composure in that, and it was. I was crying. I was literally crying in the courtroom. I had to keep my head all the way down because I was that upset, and I knew that I had to be very, very careful because the security, and they were monitoring every little thing that went on in there. So I didn't want anybody to see me emotional because I was afraid they would tell me to leave. But I can tell you oh, by the way, two of your people are here today. Oh, awesome.
Yes, I took pictures. One, her name is Wendy. I don't know if that's the name she goes by in the chat, but she's here. All right, I'll see you upstairs. What is I'm so sorry, Cindy. And Cindy is the other one, Scott.
Cindy and Wendy. Wonderful. It's great to have some more addicts.
So they came to support. So there you go. So that's all I have for you right now. I'm sorry I didn't get to you on morning break because, like I said, it was a freaking zoo.
You're good. You do you. Make sure you get up everything you want to. So, Jules, thank you so much. Appreciate you as always. I'm sure we'll be in touch here soon as things continue. Thank you, Jules.
Yeah. All right. Just take care.
You
Tell
too.
Everybody I said hello.
Oh, you're doing it now. Okay. Thank you.
Hello and goodbye. I'll see you guys later. All right, bye-bye.
Bye. A big thanks from Jules for the information. Yeah, a lot of drama A lot of drama. Shout out to Cindy and Wendy, who are in court today. Appreciate them being there as well. That's wonderful. We did notice the extra bailiffs at the back of the court, and now we have the backstory as to why. Let's see. What is this on? Okay, that I don't need. All right, we're good. Did I play through all the? I think we played through all the guesses, right? Let's see. Yeah, the very end of the guesses ends like this. By the way, Jim Bob with infinity, Heather with 17,000, 13,000, 5,000, 4,000, 3,000, and then drops down to, under 3,000. So I'm pretty sure we're not going to hit the 3,000 range. You guys here at the end, it was a good guess, but I'm pretty sure we're not going to get that far. So thank you for that. All right, Jules with all the tea. Yes, definitely. A lot of drama. Let's see. Anderson called her a prosecutor. Yeah, there were some jabs in there for sure. Okay. Yes, I don't know. I can't really comment on that. I'm not familiar with that case. I don't know the issues. Clearly, serving time for something. It's a big deal. I mean, this is life changing. Carla Bragg, welcome to the gallery. Thank you very much for joining us as a member. Make sure you help yourself to the emojis and take a seat by typing !seat in chat. Reserved seating for members. May I counter you a bit? Instead of drama, could we call it high emotions? Liam, yes. I had high emotions. So we're gonna take a deep breath and continue here. And I'm gonna do some thinking. Probably tonight, I'll stare up at the ceiling and go through my feelings. Let's see. This was in the morning, Pauline. What was reported? That was as she was arriving to court. Where can I listen to the proffer later? Gypsy T, it was on our last live stream. It was the last bit of the live stream before we cut from the courthouse feed. That's where you'll find the proffer. Okay. Stacy Whitsitt, welcome to the gallery. Thank you very much. Great to have you here. Yeah, this information we got from Jules allows us to put all the pieces together. Now we understand why what happened. Why she was out of breath. She had literally been running from protesters.
There's Mr. Elliott.
Judge is logging in. I'm logging in
There's
right now
Mr.
as well.
Altenburn. Let's talk about the dependency court order instruction. I've now had a chance to review Mr. Anderson's proposed edits. I didn't know if Mr. Elliott or Mr. Anderson wanted to say anything on them.
Briefly, I would defer to Mr. Anderson on the details. It was a continued attempt to make these a little less mind-numbing, simplify them down to something more important, and make sure they had a little more balance.
Your Honor, what I did was go back, review the prior order the court had drafted, and compare the orders themselves, and then reviewed as much of the notes as I possibly could on what transpired then as testified to now. And the goal was to try to reduce down to the bare essence those portions of the orders that were pertinent to what the jury is being asked to do here. The idea being that the simpler the orders are, this order is, and the simpler the, quote, rules are, the less questions we're going to get. This is a very intelligent jury that asks a ton of questions. My concern was that if we give them too much or virtually anything that isn't explained and suited to what they're doing, we're just going to have we're going to spend a lot of time answering questions when we really need to be concluding the case. So the idea here, going through the October 14th order, and this is not perfect by any means. Obviously, you'll see there's a typo and a word or two left out here. But the goal was at the beginning and the end to put in a caveat that the court has, without going into great detail, but that the court has determined the following causes of action are not subject to the immunity. And I think that probably the top of the page on page 2 there needs to be a little stronger than what I've got. And then you'll note at the very end, page 8 of 8, I've got the same warning. So I wanted to begin and end with the warning, the first one being pretty basic, and the second one being more in line with what I thought what had been agreed to with everyone. And then we go through the October 14th order as to the people involved, the November 10th order as to the people involved. There, in the November 10th order, if you look at page 5 of 8 under other relevant requirements in the bottom, it says that the November 10 order allowed Maya Kowalski to have religious artifacts. A sentence that I did not put in there, but I think should be put in there, are words to the effect, but there was no prohibition on her having religious artifacts before this order. The reason being that by simply stating there's an order, in the perception now allowing religious artifacts, the jury might get the idea that prior to this, they were prohibited somehow, and so there had to be a court order for her to have them, and that wasn't the situation. She was allowed to have them under their patient's rights, and the order was really clarifying some problems that had arisen. Then on page 6 of 8, I thought I had deleted this. Apparently I didn't. The December 9, 2016 order, as I read it, really does not affect anything that we're talking about here because it has to do with a birthday and who gets to go to the birthday. And again, things like that while technically if we're going to be complete with all the orders, it goes in it, still, I believe that the less things like that are in this, and the more we focus the jurors onto the specifics of the orders that, for lack of a better term, count, the more efficient this will be. I know on the December 16th order, I have been wondering about the statement about the dependency court allowing Johns Hopkins to supervise the video calls. His medical staff could suspend those calls only insofar as, again, I don't know, in my review of the original order, it did not have the language attendant to that sentence and that portion of the order. But clearly, based on the other orders, Johns Hopkins was always subject to its own internal rules and regulations. And my concern here is that the jury has heard a lot about the patient's rights, statement of rights, incorporated into the same packet that has the release the defense wants to argue in favor of. And it clearly was part of the agreement between the parties and part of their website and part of this case. And so I wanted to be able to include in this something to the effect of according to its rules and regulations, so on and so forth. So that change would go right before this was a change from the November 10 order. I have not put it in yet, but I think it would be appropriate to do that. Although, again, it wasn't specific to this part of the order, but it's specific to virtually every other part of the orders. Every other order, when they defer to Johns Hopkins, it again ties it back into, and by the way, you have to follow your own rules and rights that you've given. And then we go through to the December 27th order on page 7, and we go through the specifics of that. Again, I tried to track in readable, because some of the orders, I think everyone will agree, are difficult to navigate for us, and because there are inherent inconsistencies. And for the jury to do that by just putting the data out there, which may be, from appellate purposes, the cleanest, still, I think it is overall better, and the appellate court would understand the problems with just reciting the terms of the orders because of the inconsistencies involved and the fact that the jury's going to come back and say, well, this order says this on this time, but then on this time the order says this, and what about inside the order itself? The order says you can do it this way, but then down here it says you can't do it this way. And there are plenty of those in the orders as drafted in the shelter action. So then on the last page, you'll see, again, the caveat, which I put at the end after the dependency order, January 13th, discharges Maya. And that is, speaks for itself that none of the above orders provide them with immunity or other protection. It should be from plaintiff's claims for specific events and then false imprisonment, so on. The only other question I have in conclusion is the issue about the ketamine order. The defense has made much in the case, well, I believe will and has to a certain extent, talked about whether or not the Maya not using ketamine after she left was some indication or admission that the plaintiffs...
I see that as a different total issue than talking about visitation. Yes. That's not.
I'll shut up about that.
Let's not mix those concepts.
Got it. Well, then I'm done. That's my explanation for the order. Obviously, open to whatever suggestions and comments.
Your Honor, the truth is Mr. Anderson's just never wanted those orders in front of the jury from the first day of this trial. You've been trying to get them in front of the jury now for 2.5 weeks or longer. I spent more than a day trying to put together something that I thought would be as concise as I could that quoted those orders. I don't know how much time you spent, but from my read of this, you rather carefully took those orders that I had provided to you and put them into simple English and was accurate about what is in them. And, you know, all this was done, my order was submitted to you, I don't know, sometime middle of the latter part of last week. And now when we're ready to read it this morning, he wants to make a wholesale change to the whole thing. Mostly he wants to take out the sections he doesn't like and leave in the sections he does like. And so my front end on this is that I do believe that your provisions of this were an accurate transition from the orders I gave you to something that will hopefully make the jury understand it better and faster than what I had provided to you. So I don't think it needs all of these changes. I did know, by the way, that the last time we talked about these orders, we talked about, because the October 14th order was effective October 13th. I'm pretty sure the last time around we called it the October 13th order. And maybe we should stay consistent on that. But the rest of this, I mean, unless you have questions about it, I think that you did a good job, and I'm content with you staying with what you wrote.
I am not going to change horses at this point in time. I believe that the proposed changes that Mr. Anderson would make this not a neutral and balanced recitation of the orders. So I'm going to stick with what I said with my change this morning, and obviously not including that one sentence that I continue to struggle with. And again, we can continue before this actually gets put into the final package that goes to the jury after all the evidence is in. We can massage the language a little bit more, but I'm not going to. Now, I will say, if the parties want me to take out the birthday order and go from 5 orders to 4 orders, I don't think that changes anything, so I'm happy to take it out if you want to leave it in.
For clarification, actually from tribal lawyers as well, has there been any reference that we disobeyed in any fashion?
No, that's my point. I mean, there's no allegation that
I think it may need to be added in later, depending on what they do when Kathy B's on the stand. But for this juncture, I think
it's a half of a page, so it doesn't materially change anything. So if there's the possibility that it's going to be necessary, I don't want to tell them there's 4 orders, and then next time tell them there's 5. So,
Your Honor, could we again consider adding the paragraph at the end, which is kind of balances out? There's a short statement at the beginning that doesn't affect the claims, but having that statement at the end after they've heard all this, we think would be important to put it in the right perspective.
I've already said it. I'm not going to say it again in the instruction.
Well, so, where was it in that instruction? Was it at the beginning, Judge? Your order. I don't have it up here with me.
Judge, can we say the 1014 order was effective 1013? I know it stated 1014, but it was effective 1013.
What?
Yeah, I think it was on pro time for the 13th.
Just backdated.
So what I'll do, which was effective, was that 2:30 a.m.?
Yes, either 2 or 2:30. I've got it. I've got the order. I'll look.
Well, let's do it right this second.
Lots of noise in the courtroom.
It's effective 2:30 a.m. October 13th, 2016. First page on placement and shelter.
So it wouldn't really, though, affect anything going on during that day.
I don't think there were visitation issues during that day. I don't honestly remember when Mrs. Kowalski was removed from the premises. But we've already explained it to the jury as the 13th. I just think it's important to keep it consistent.
All right.
This is just so you can see what I've just done.
Yeah. Thank you.
Anything else on adding that clause? Mr. Anderson?
No, Judge.
Now the question is, when am I going to read this?
I prefer to have it read now when they first come in, rather than at the end of the day when they're tired or more tired.
So right when the jury comes in?
Yes, sir.
And I must state that I do not agree with making this, and I've been consistent with orders during the course of the trial throughout, that the plaintiffs object to reading 1 or 2 of the instructions that are going to go at the end of the case in the middle of the case, because it unduly emphasizes some orders, instructions over other orders, and by doing so minimizes the other orders. So we again urge the court to not read this during the middle of the trial, because then it will be read twice and the jury will have heard this order, and I believe we had one order earlier 2 times, rather than, and all the remainder ones once at the end. And it does give the impression that these instructions, jury instructions, I shouldn't say orders, control or are more powerful or somehow should be attended to closer than the instructions on all the remainder. So that's our objection to it.
Anything you want to add, Mr. Altenberg?
Well, in context, when Ms. Beatty testifies about these things, knowing these things which are more or less legal facts to some degree is very important. You had talked about giving this to them in the end in writing. I wasn't 100% clear to me whether you plan to read it again at the end as well as give it to them in writing.
I plan on it being in the actual physical packet. that goes back with it.
I mean, unless there are significant changes to it, I don't know that I would be demanding that you read it twice so long it was in the packet. They went back and they understood that what they heard once before was in the packet for them to double check their interpretations.
So you're suggesting that we not read?
No.
She wants to read
The
it.
jury has had so many questions about these orders.
Yeah.
Questions on a lot of different.
I mean, I want it read right now.
Yes, it needs to be read again later.
And she wants it read twice, so that's fine.
I agree. The jury has been really on this particular issue, so I'm going to read it. I will read it when the jury comes in. Now, here's the next question. I'm not going to physically give them paper right now. I do have the ability to place it up on the screen as I read it.
That's up to your honor, either way.
I don't think that they will be paying attention to the screen and not you. I would suggest the court simply read it.
Well, I'm going to read it.
Yeah.
No, it would be helpful for them to follow
put it
along.
up at this point.
Adults are visual learners. They learn better when they can hear and see something than if they just hear it. So if you've got the ability to do that, I would like
Because they're going to write it down. They're going to write down
It's going to
notes.
take them forever to read through all this while the court is also.
I'm going to read it at my normal speed, and I will.
This is going to be long.
The only thing is it makes it a little difficult because I'll be looking this way, and I have to control it over here. But I think I can do it without any sort of delay. So
Judge, I have a small issue before the next witness. Can we take that up now?
quickly, yes.
Yes. So the next witness after you're done will be Miss Alicia Alcide, who's a nurse who was involved somewhat in the taking of the pictures on January 6th. At her deposition, counsel for plaintiffs spent a good bit of time addressing why wasn't she discovered earlier? Did risk management look for her? And I guess moving in limine or tennis said that not be an issue it's not an issue for this jury. It was a discovery issue for us and for the court, but would request that not be an issue, that be put in front of this jury.
Wait, so I'm sorry, you want me to preclude what precisely?
Questions regarding why wasn't she identified to the plaintiff a year ago? Did risk management come looking for her? Did they send emails? Did they try to find the nurse who was in the photos? Did they? All of those questions that have nothing to do with the issues in front of this jury.
Well, there is certainly something very curious in this case. Since her hands are in photographs, and these were seminal to the plaintiff's case for 5 years, I think some questions about was she aware that her involvement in this case was sought, and if so, why didn't she speak up? I don't want to get into the issues of who, if she says, no, I had no idea, then I guess it's over. But if she says, yes, I did know about it, and just nobody ever asked me, then I think that is an admissible fact for the jury.
It's not, I'm sorry. It doesn't go to any issue for this jury to decide, Judge.
Just advise.
It seems that really what you're trying to do is create a spoliation-esque type of argument, which isn't an issue for the jury. There's been no finding by the court of spoliation, so I don't think we need to do that. I'll try something.
Judge says, I don't think
So
we
you're
need to do that. But is that a
sustaining the
ruling?
request for the objection?
Yeah, I'm going to.
Cruels knows that was not a ruling. She's like, I need you to say the magic
that line of
words.
Questioning.
Thank
So I will grant the oral tennis motion.
I'm not sure of the timing, but again, has the defense made any headway on the reports of 2017 reports of employees?
Can we address that after this next witness?
We said at lunch.
Well, whatever. I just know the jury's waiting. And
Whatever.
Did they have them?
It's a yes or no, isn't it?
But did Your Honor want to address that now?
I'm sorry, I didn't focus on what Mr. Anderson said.
They would like to address the 2017 further inquiry as to the performance evaluations. Do you want to do that now, or would you like to do it at the next break?
What's the answer?
Okay.
The answer is we do have a subsequent performance review. There
We do have.
spans of time from 2017 through 2018. It's the next performance review. Whether that date backs all the way to October, I can't necessarily tell. It doesn't appear to be that way, but they're welcome to it. I'm happy to produce it.
We'll send it over.
Okay.
That's skirting the issue. We don't have a performance review from the hospital for the time span of this corrective action as from Ms. Beatty from the end of October through July of 2017. It's not there.
Do you want to take a deposition on the issue? Because I'm going to need facts if you're asking me to do anything. I can't just accept representations from lawyers because that's case law says that's not evidence and it's not the same as sworn evidence.
And the answer is yes.
And I think they should be required to produce.
I said that they had to have somebody on warm standby. So why don't you get the documents over? Are you able to do it in the next few minutes?
Yep.
Send that over, and then perhaps during one of the depositions that is being played, you can look at it, and then we can talk about when the deposition that you want to take will occur.
Our biggest concern is what the court pointed out, which is were there reviews of other employees at the same time, and so I don't know if they're going to redact or how they plan to do it, but we would like to see some proof of that.
The person from All Children's is going to have to be able to testify as to what happened with everyone else at the time and the salary issues and
why there isn't one. I understand.
Okay.
Thank you.
So I'm going to take this down until I'm ready to leave.
Judge is doing his techie stuff.
Anything else before we bring in the jury?
So at this point in trial, at some point, the judge, here very soon, I think right now, the judge is going to read jury instructions
Two things,
to the
witnesses
jury.
for tomorrow, and I think we were told we would get an answer on Fabre.
Witnesses for tomorrow are Dr. Jennifer McCain.
Who was it?
Dr. Jennifer McCain. I think he's a pharmacist. James Schott. Jason Banker is our billing person. And we're hoping to play the video depositions of Dr. Hanna and Dr. O'Leary at a minimum.
Concerned about the pharmacist Schott. You're talking about the pharmacist from CBS, Schott?
Quorum.
Quorum, same thing.
We can talk about that after the jury leaves for the day. Anything else? Let's bring in the jury.
All right, we're ready as they hammer out some of these details. They are going to read jury instructions. It's not over yet. This does not mean the jury's going to go start deliberating, but the judge has wanted to read some of these instructions earlier in the case because of the nature of some of the testimony that's come in that the plaintiff has introduced. They want to bring in this instruction. It's almost like a curative instruction, but it's hard coded into the jury instructions, just to remind them or make fresh in their mind while they're still hearing evidence about the the boundaries of where where this evidence lies and who could be to blame.
I want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that correct?
Correct.
You weren't approached by anybody. Is that correct?
Correct.
And you didn't see any media accounts. Is that correct? Okay. Before we call our next witness, I'm going to give you a lengthy instruction concerning the dependency orders. I'm going to tell you that you're going to get this in writing at the end of the case before you begin to deliberate. But I'm going to go ahead and read it to you now. It should also be put up on the screen as well. I did it properly. Okay. Members of the jury, I told you that I would address the issue of contact allowed by the dependency court during Maya Kowalski's stay at Johns Hopkins All Children's Hospital. This instruction explains the specific dates and restrictions the dependency court imposed in the 5 orders that address contact with Maya Kowalski. The restrictions changed over time, so understanding the dates is important. This instruction will be provided to you again in the court's final instructions to you. The court previously concluded that Johns Hopkins All Children's Hospital had reasonable cause to initiate a call to the Florida's Child Abuse Hotline. Therefore, Johns Hopkins All Children's Hospital is immune from any civil claim which might otherwise result by reason of reporting the suspected abuse. Having said that, Johns Hopkins All Children's Hospital does not have immunity for any of the claims being presented to you as the jury. Prior to October 14th, 2016, there was no dependency court order governing Maya Kowalski's stay at Johns Hopkins All Children's Hospital. From October 14th, 2016 through January 13th, 2017, Maya Kowalski could not be discharged from Johns Hopkins All Children's Hospital without the dependency court's approval. The fact that Maya Kowalski was kept in the hospital under dependency court order, the length of her stay in the hospital, and the fact that Beata Kowalski could not visit Maya Kowalski are not matters for which Johns Hopkins Children's Hospital is responsible under any of the claims being presented to you. The dependency court placed Maya Kowalski in the shelter care of the Department of Children and Families when it entered its first order on October 14th. Although this status limited some of the parental rights of Jack and Beata Kowalski, it did not limit their right to be informed about Maya Kowalski's treatment and to participate in decisions concerning her treatment. The court will now instruct you on the relevant terms of the 5 dependency court orders. 1. The October 14th, 2016 order. The dependency court entered its first order affecting contact with Maya Kowalski on Friday, October 14th, 2016, which was effective at 2:30 a.m. on October 13th, 2013. Beata Kowalski. The October 14th order totally prohibited Beata Kowalski from having any contact with Maya Kowalski, either in person or by other means such as telephone, email, text message, or by any other form of electronic communication. Jack Kowalski and Kyle Kowalski. The October 14th order required that any visit between Maya Kowalski and Mr. Kowalski be supervised by an adult approved by the Department of Children and Families. Kyle Kowalski was permitted to visit Maya Kowalski with Mr. Kowalski. There was no time limit placed on these supervised visits. The department, not Johns Hopkins All Children's Hospital, was required to make all efforts to identify and select a supervisor to assist with the supervision of these visits. The Department of Children and Families is required to provide such supervision in the cases it files. This order did not create any special rules that the department was required to apply in setting the rules of supervision. The first order did not prevent Johns Hopkins All Children's Hospital from applying its own rules regarding visitation and communication with other patients unless those rules conflicted with stricter requirements in the court order. That is to say, the hospital could not use its own rules to override the stricter rules in the court order. 2. The November 10th, 2016 order. The dependency court entered its second order affecting contact with Maya Kowalski on Thursday, November 10th, 2016. The second order changed the terms of the October 14th, 2016 order regarding contact on a going forward basis. Beata Kowalski. The November 10th order allowed Beata Kowalski to have supervised telephone calls with Maya Kowalski. The dependency court directed that either the guardian ad litem or the case manager supervise these telephone calls. The calls were to be at a time convenient to Johns Hopkins All Children's Hospital, as well as the guardian ad litem or case manager at the Department of Children and Families. The dependency court did not provide that Johns Hopkins could supervise the calls. The November 10th order also allowed Beata Kowalski to have contact with Maya Kowalski through written correspondence. Each of Maya Kowalski and Beata Kowalski could send the other letters, magazines, or other written materials. The dependency court required a designee of the Safe Children's Coalition to review the material before delivery. The designee was required to promptly forward approved materials to either Beata Kowalski or Maya Kowalski. Any material the Safe Children's Coalition designee determined to be inappropriate could be withheld, but the Safe Children's Coalition was required to advise the lawyers in the dependency action of the reasons the written material had been determined to be inappropriate. Johns Hopkins All Children's Hospital had no role in this process. Jack Kowalski and Kyle Kowalski. The dependency court's November 10th order allowed unsupervised telephone and in-person contact between Maya Kowalski and her father and brother. Mr. Kowalski and Kyle Kowalski did have to abide by Johns Hopkins All Children's Hospital's rules, policies, and visiting hours. Maya's treatment was to be given priority, but Johns Hopkins All Children's Hospital was encouraged to provide Maya Kowalski as much contact with her father and brother as possible, provided it did not interfere with Maya's care. Mr. Kowalski and Kyle Kowalski were prohibited from discussing Maya's pain, its causes, the allegations against her parents, or when or how the dependency action would be resolved. Mr. Kowalski and Kyle Kowalski were required to be positive about Maya's rehabilitation efforts and progress, and to follow the recommendation of the Johns Hopkins All Children's Hospital staff as to how to interact with Maya. The number of visitors and the time of the visits required approval in advance, so no unannounced visits were permitted. Friends and other family members. The November 10th order allowed Maya Kowalski and Jack Kowalski to designate two of Maya's friends and two other relatives as proposed visitors, subject to a background check and clearance by the Department of Children and Families. Once cleared by the department, those individuals were allowed to have unsupervised visits with Maya Kowalski. These visits, though, were subject to the same conditions applicable to Mr. Kowalski and Kyle Kowalski as discussed above in the November 10th order. Michael Kelly, Maya Kowalski's attorney. The November 10th order directed Johns Hopkins All Children's Hospital to make the necessary arrangements for Michael Kelly, Maya's attorney, to have in-person and secure telephonic Let me start again. I apologize. I misread. The November 10th order directed Johns Hopkins All Children's Hospital to make the necessary arrangements for Michael Kelly, Maya's attorney, to have in-person and secure telephonic confidential communication with Maya Kowalski. The other relevant requirements. The November 10th order allowed Maya Kowalski to have religious artifacts that did not interfere with her rehabilitation. The dependency court encouraged Johns Hopkins All Children's Hospital to allow a Catholic priest to have regular contact with Maya. If a person authorized to have contact with Maya Kowalski violated Johns Hopkins All Children's Hospital policy, the dependency court's order, or negatively affected Maya's rehabilitation, Johns Hopkins All Children's Hospital was authorized to suspend that person's contact with Maya Kowalski. 3. The December 9th, 2016 order. The dependency court entered its third order affecting contact with Maya Kowalski on Friday, December 9th, 2016. This third order was a special order to address Maya Kowalski's birthday. It allowed Mr. Kowalski and Maya Kowalski's uncle, Scott Kowalski, to visit Maya on her birthday in accordance with Johns Hopkins All Children's Hospital policies. The visit would only be permitted if, in the judgment of hospital staff, the visit would not adversely affect Maya's emotional condition or impede the hospital's rehabilitation efforts. 4. The December 16, 2016 order. The dependency court entered its fourth order affecting contact with Maya Kowalski on Friday, December 16, 2016. That fourth order changed some, but not all of the terms of the November 10th order. Beata Kowalski. The December 16th order permitted Beata Kowalski to have video contact with Maya via Skype, FaceTime, or similar electronic means at times and under conditions approved by Johns Hopkins All Children's Hospital. The dependency court allowed Johns Hopkins to supervise these video calls, and its medical staff could suspend those calls. This was a change from the November 10th order. Despite that change to video calls, the December 16th order did not change the November 10th order's requirements for a designee of the Safe Children's Coalition to review the written materials between Maya Kowalski and Beata Kowalski. Jack Kowalski and Kyle Kowalski. The December 16th order did not change the November 10th order concerning Jack Kowalski and Kyle Kowalski's contact and communication with Maya Kowalski. The provisions of the November 10th order continued to apply to Jack Kowalski and Kyle Kowalski. Mark Zimmerman, Maya Kowalski's attorney. The December 16th order directed that with reasonable notice to Johns Hopkins All Children's Hospital, Maya Kowalski was allowed to have secure and confidential communication with her attorney, Mark Zimmerman. This provision altered the identity of Maya Kowalski's attorney from the November 10th order and slightly altered the obligation on Johns Hopkins All Children's Hospital. Other relevant requirements. The December 16th order did not change the November 10th order concerning other relevant requirements. The other relevant requirement provisions of the November 10th order continued to apply. 5. The December 27th, 2016 order. The dependency court entered its fifth order affecting contact with Maya Kowalski on Tuesday, December 27th, 2016. That fifth order substantially changed contact with Maya on a going forward basis. Beata Kowalski. The dependency court's December 27th order allowed daily video calls with Maya Kowalski at approximately 11 a.m. and 5 p.m. daily. The dependency court permitted, but did not require, the guardian ad litem, the case manager from the department, or any member of Johns Hopkins All Children's Hospital staff to supervise the video calls. Beata Kowalski was not permitted to make any disparaging comments. Johns Hopkins All Children's Hospital was allowed to suspend the video call if Beata Kowalski violated the hospital's policy, the December 27th order, or acted to negatively affect Maya's rehabilitation. Jack Kowalski, Kyle Kowalski, Scott Kowalski, and Wendy Kowalski. The dependency court's December 27th order allowed each of Jack Kowalski, Kyle Kowalski, Scott Kowalski, Maya's uncle, and Wendy Kowalski, Maya's aunt, to have unsupervised, unlimited visitation with Maya. Jack Kowalski was required to announce the visit at least 2 hours in advance. These visitors were required to abide by Johns Hopkins All Children's Hospital visitation policy. They were not allowed to make any disparaging comments. Johns Hopkins All Children's Hospital was allowed to suspend any visit if that person violated the hospital's policy, the December 27th order, or acts to negatively affect Maya's rehabilitation. Other persons. The dependency court's December 27th order prevented any other persons besides the 5 Kowalski family members identified in the December 27th order from communicating with Maya. The order discharging Maya Kowalski from the hospital. The dependency court entered an order on January 13th, 2017, discharging Maya to her father's custody. At that time, the visitation orders ceased. That concludes the reading of the court's instruction to the juries.
Okay, so just keep in mind the jury has been asking questions
With that,
approach this.
We're now going to call our next witness.
And we've had many...
call Alicia
Alsteed. We've had many witnesses testify to things that could be construed as faulting the hospital for some of the things that were actually covered under the dependency court ruling. So throughout this, the judges said, I'm going to give you instruction about that. We're going to address that. And they've been trying to finalize it. This has been pushed on the back burner so many times. Every time we have pressing issues with evidence, that was always taking precedence. And so this has just been delayed and delayed and delayed. I think ideally the judge would have read this much earlier in the trial, but they just couldn't agree on the language. Even right up until right before he read this, they couldn't agree on the language. So that was provided to the jury for that reason. Oh man, there's a spam call coming in.
Face the clerk and raise your right hand.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. All right, right this way.
May it please the court? Good afternoon.
Hi.
There's a microphone that's been pushed out of the way a little bit. If you want to, yeah.
Okay.
Make sure that you go ahead and say your name for the record, please.
Alicia Alsteed.
Okay. Ms. Alsteed, are you an employee of Johns Hopkins All Children's Hospital?
Yes.
Okay. And what is your position there?
Registered nurse.
And where do you currently work?
Right now, I'm a nurse coordinator for the Muscular Dystrophy Clinic.
Okay, can you speak up just a little bit?
I'm a nurse coordinator for the Muscular Dystrophy Clinic.
Okay. Prior to that, did you work on the 7th floor?
Yes, I did.
Okay. All right. And at one point in time, at least January 6th of 2017, were you the bedside nurse for Maya Kowalski.
Yes.
All right. Let's back up a little bit and talk about your education and training. First of all, where did you go to school for nursing?
Florida A&M University.
And just tell us about your education when you graduated.
So I got my AA at College of Central Florida, transferred to Florida A&M University, where I got my BSN, and I also have my master's in public health from USF.
Okay, and when would you have gotten your BSN is a Bachelor's of Science in Nursing?
Yes.
Okay, and that makes you an RN at that point?
Yes.
And when did you get that?
I graduated in 2005. Yeah, 2005.
Okay, and take us through your employment up to joining All Children's.
I started working at All Children's in 2010.
Okay, prior to 2010, where did you work?
I worked at a hospital in Ocala, Florida. It was called Monroe Regional Center at the time, but it's a different name now.
Okay, and you worked in that hospital?
Yes.
As an RN?
Yes.
Okay. All right. You are a pediatric nurse.
Correct.
Tell the jury why you felt called to be a pediatric nurse.
Well, so my brother was born with a hypoxic brain injury, which led him to have cerebral palsy, which is CP. And growing up, he just was sick a lot. He was in the hospital a lot, multiple doctor's visits. But throughout his life, the nurses were always really kind to him and my family, and they always took really good care of him. His home health nurses did as well, and I just knew I wanted to do what they were doing. I wanted to take care of children. I wanted to take care of kids. I wanted to help them like the way they helped my brother. So that's the reason why I wanted to be a pediatric nurse.
So thank you for sharing that.
And he's passed away, so that was many, many years ago.
So you started All Children's in 2010?
Yes.
And were you on the seventh floor?
Yes.
Okay. And remind the jury, they've heard of it, remind the jury what type of floor is this, the 7th floor, what type of patients?
It's a surgical neurosciences unit.
And for how long were you on the 7th floor?
12 years.
Okay. So it's fairly recently that you changed your position?
Yes.
Okay. And what was the reason for the change?
I just had a change in life, and I needed to be more available to my daughter, to take her to school and pick her up. That's not feasible with a 12-hour shift, so I had to find another job to be able to do that.
So back in 2016, 2017, what shift were you working?
It's the day shift.
And is that 12 hours, 7 a.m. to 7 p.m.?
Yes.
Okay. Let me just ask you a couple of questions with respect to 7th. Is it 7 North or is it just 7?
It's 7 North.
7 North, that's what I thought. Okay, with respect to 7 North, are there some rooms that have video cameras in them?
There is.
Are those just the EEG special rooms?
Yes.
With respect to regular patient rooms, do they have video cameras in them?
No.
Okay. Do you recall a social worker by the name of Kathy Beatty?
Yes.
Did you have much familiarity with Miss Beatty?
Only with the patient I took care of.
Okay. All right. And I think we mentioned this, but on January 6, 2017, were you in fact assigned to be the bedside nurse for Maya Kowalski?
Yes.
Okay. Describe for the jury the duties or what your duties were as a bedside nurse.
As a bedside nurse, my job and my duty is to take care of my patient. That could involve in following the doctor's orders, the plan of care for the patient, administer medications, assist with ADLs, which is activities of daily living, helping with procedures, and be an advocate for the patient and family, just whatever the patient needs.
With respect to your duties as a bedside nurse, would you sometimes have to assist patients either with dressing or bathing or other issues like that?
Yes.
Tell the jury what was your goal with respect to protecting the modesty or dignity of your patients when you would have to assist with those types of activities.
Do you mean like do you mean my patients in general? Like,
well, in general, and then we'll get to my.
Okay. To protect their modesty. I'm sorry, could you repeat the question?
Sure. So if you had to help a child either undress or bathe or assist them in those types of intimate type of things, what would you do, or how would you try to protect their modesty and their dignity?
Okay. I would make sure that they are covered. If I couldn't get them into like the bathroom, or if there was someone else in the room, I would ask them to leave. But I would make sure they're covered, and I would just protect their privacy.
Do you recall on January 6, 2017, that Maya Kowalski was going to be being discharged from the hospital to go to court?
Yes.
Okay. Can we bring up Joint Exhibit 1001, 1572? No, 1572. Thank you. Oh, where's it? There it is. Freeze it. Okay. So, do you see your name on there, Miss Alcide? Let's see. Just above the continuous infusions, that line above there, it says result comment. Maybe you could highlight that for us. The second paragraph.
I see my name, but not where continuous infusion.
No. I was just directing.
Yes, I do see my name under medication administration.
Okay. I'm looking a little bit further down. It says 1/6/2017, 1056. There we go. Thank you. Okay. Under the result comment, it says Alicia D. Alcide. Is that you?
Yes.
And then it says patient discharged with uncle per court order will be readmitted today. Do you see that?
Yes.
Okay. Do you recall, in fact, that Maya was going to court with her uncle that day?
Yes.
Okay. And so this is at 10:58. Does that mean that's the time that she actually left, or on or about that time? That's why you charted it?
I can't say that's when she left. From me, this looks like a medication record, and just going by my documentation, I'm charting that I did not give her the flu vaccine.
Okay.
Because she was going to court.
Okay. But in any event, at some time that morning, the patient had left with her uncle to go to court.
Correct.
Okay. All right. Thank you. Prior to her leaving, were you requested by Miss Beatty to assist with some photographs?
Yes.
Tell us what you recall about that.
Objection, call for narrative.
Sustained.
Okay. Tell us what you recall about what Miss Beatty requested of you.
She asked me to assist to take some photos of Maya.
Okay. All right. Where did these photographs take place?
In her room.
In Maya's room?
Yes.
So Maya was not moved to another room in order to take the photos?
Objection, leading.
Sustained.
Was Maya moved to another room to take the photos, or were they taken in her room?
I don't recall her being moved to another room to take pictures.
Okay. So your best memory is they were taken in her room?
Objection,
correct.
Leading.
Correct.
All right. What did you have any concerns or thoughts of concerns when Ms. Beatty asked you to come in and assist with taking photos?
No.
And why not?
I just didn't think it didn't seem like a concern to me at the time.
Were you aware that Maya was there under a shelter order?
Yes.
Have you had experience with other kids being placed in the hospital under any type of dependency or shelter orders?
Could you repeat that? I'm sorry.
Sure. in your experience as a nurse on 7 North, have you seen or been aware of other children that have been on that floor as a result of either shelter or dependency orders?
Yes.
Are you aware of other children where photographs have been taken?
Objection, relevance.
Sustained.
Okay. With respect to Maya Kowalski's photographs, did your prior experience with, let me start that. Did you have prior experience with other children being photographed?
Objection.
Sustained.
Okay.
That was
All right,
the same
so let's
question.
go to what actually occurred. Do you have detailed memories of what happened?
No.
Okay, but let's talk about what you do recall, all right? First of all, let me bring up Trial Exhibit 2604006. Okay, so this is I think stipulated, a picture taken on January 6, 2017, before Maya Kowalski went to court. Are you in that picture?
Those are my hands.
Those are your hands. Okay, all right. And I see that Maya is in pink shorts, and I think what's been referred to as either a training bra.
Objection. Leading.
Okay.
That one's okay.
I want to lead. I want to lead.
Do you see that Maya is in pink shorts and what would be referred to as a training bra or athletic bra?
Yes.
Okay, all right. With respect to your involvement when you entered the room, who would be the person that would assist Maya in getting undressed?
The bedside nurse, which would be me.
Okay. And with respect to the photographs that were taken that day, that morning, do you have any recollection of either you or Miss Beatty holding Maya down?
No.
Do you have any recollection of Maya screaming or yelling no?
No.
If Maya had been screaming or yelling no, would you recall that?
Yes, I would recall that.
If you had held her down, would you remember that?
Yes, I would remember that.
If Miss Beatty had held her down, would you remember that?
Yes.
All right. So, with respect to photographs that were taken that day, you would have left at 7 p.m.?
Yes.
Objection.
Well,
Leading.
yeah, my shift was from 7 to 7 p.
Okay. So if there were photographs taken after Maya returned that day, you wouldn't know about that, correct?
Objection. Leading.
Could you repeat the question?
Sustained on the leading.
Okay. Do you recall whether or not Maya had returned prior to you leaving for the day?
I don't remember.
Okay. All right. That's fine. All right. Can we put up Trial Exhibit 2604004? Is that your hand?
No.
With respect to, can we put up side by side 2604006 and 2604004? Okay. So, do you notice the difference in clothings in the photograph?
Yes.
Okay. So, can you describe the difference that you're observing?
In one picture, she has on a shirt or a jacket with colorful top underneath, and the other picture, she has on pink shorts and a white sports bra.
Okay. So, and then that's not your hand in the 2004 one? The one on the left?
No, that's not my hand.
Okay. There's been an assertion in this case, Ms. Alcide, that after the photos were taken with the pink shorts and the white bra, that you then stripped Maya, exposed her to Kathy Beatty, and put her in a different bra. Did that occur?
No.
And how do you know that?
I would not. What do you mean by expose?
That you stripped Maya naked, half naked, and Kathy Beatty was standing there watching you do it.
I would protect my patient and cover her up.
That's not something you would do?
No.
Do you recall, in fact, helping Maya change into an outfit to go to court?
Yes.
Do you recall what that outfit was?
I don't recall exactly what it looked like, but it was a dress or skirt, something of that type.
Okay, all right. So let's put up $2604018 and $2604008 next to each other, please. Do you see those photographs, Ms. Alcide?
Yes.
Okay, so in those photographs, again, she's wearing different shorts, different bra, correct? Compared.
Objection, leading.
I'm going to overrule that one.
Okay. Correct?
Yes.
Okay, all right. Now, I do notice that there is in the 2604018, there appears to be a stuffed monkey of some or something. Do you see that?
Yes.
Would that indicate to you that this was Maya's room?
Yes.
Okay.
Objection, foundation, predicate. Overruled.
All right. Let's bring up 2604011 and 2604016. Okay. So, do you see the difference, any difference in that photograph with respect to the blue blanket?
Yes.
And what do you see is different?
In one photo, well, the photo on the right, it's like it's neat. The photo on the left, it's not folded, or it's kind of disheveled a little bit.
So after the initial photographs were taken with the white bra and the pink shorts, were there a second set of photos taken that morning, Miss Alcide?
No, not to my knowledge.
Okay. Did you strip Maya, put her back in shorts and a shirt, fold a blanket, and have her lie down again to take more photos?
Not that I can remember, no.
You can take those down.
Why are those hands in the picture if she wasn't being held down? Just asking the question.
To your recollection, was January 6, 2017 the first time you had been assigned as Maya's bedside nurse?
Yes.
Okay. Any particular reason, or that's just how it occurred?
I honestly don't remember.
Okay, but you do know that that was your first time of being a nurse?
Yes.
Okay. Thank you.
You're welcome.
Mr. Anderson.
Thank you, CG. Appreciate your generosity.
Ms. Alcide, am I pronouncing correctly?
Yes.
The name. All right. So, right before this testimony, did you meet with the defense lawyers about your testimony?
I did meet with them, yes.
How long?
An hour, 30 minutes.
And before that, how many times?
None.
That was the first time?
Yes.
Any phone conversations?
We did have one phone conversation.
How long?
30 minutes.
Okay. Now, you up to this point of Maya, you had never heard of a child having their clothes taken off for photos, had you?
Can you please repeat
Sure.
that?
Sure. Prior to this event with Maya Kowalski, you'd never heard of a child having their clothes taken off of them for photographs. True?
I've never said that.
Well,
no.
All right. So you have heard of children having their clothes taken off?
What do you mean by heard?
I mean, like Maya's taking all of her clothes except for short shorts and a bra off, like that. You do remember that happening before or not?
Yes.
Okay. With taking do you remember your deposition of August 24th, 2023?
Yes, I remember some of it, yes.
And you were sworn to tell the truth at that point?
Yes.
And that was what? How many months ago? Several months ago, I guess. Is it true at that point you could never remember?
Excuse me, you have a page.
Yes, page 28, line 19. This was the only time in your career you had participated in something like this, that is, taking a child's clothes off.
Could you please reword what you're trying to question right now? Because could you please reword?
Would you agree this was the only time in your career that you had participated in something like this? I mean, taking clothes off a child in order to photograph them.
Like me, myself, taking clothes off of a child?
Yes.
No.
Okay. Well, let me ask you if you gave this answer to this question. Beginning page 28, line 19, strike it. Isn't it true that this was the only time in your career that you had participated in something like this? And when I say, when I say something like this, I mean taking the clothes off of a child in order to take photographs of them. Answer, I can't really recall any other times. Do you recall giving that answer to that question?
Yes.
Would you like to see it to confirm, or?
No, that's...
And nobody from risk management called you about this, correct?
Called me about what?
Taking the photographs?
When I was initially contacted about this, yes, they did they wanted me to confirm that those were my hands in the photograph.
Okay, but I mean at the time that it was done, had you been in contact with risk management?
No.
So your
You mean in 2017?
Yes, ma'am.
No.
So your directives on what you were supposed to do came from Miss Beatty, is that right?
Correct.
All right. And during the course of this, you changed Maya's clothes, true?
Yes.
And in fact,
hey guys, focus on the testimony. Don't
up until
don't
this
take apart
point,
the witness, please.
Well, strike that. It actually came to you or whoever else was in there taking Maya's clothes off to the point where large parts of her skin was exposed. Everything but her training bra and her short shorts. True?
Could you please repeat what you just said? There's a lot of words. I'm trying to just...
Well, absolutely. You had never, up until this point, you couldn't recall how it happened that Maya's clothes came off to the point where large parts of her skin were exposed, everything but her training bra and short shorts.
Yes.
So that did happen.
What happened?
Maya's clothes were taken off down to the point where she was only wearing short shorts and a training bra, right?
Yes.
And you only remember one set of photographs being taken.
Yes.
Now, who else was in this room besides you and Miss Beatty?
I only recall me and her being in the room.
All right. Well, let's take a look at some photographs, because I could have sworn I heard you state on direct examination that those were not your hands. Do you have a photograph?
What's the number? Just tell us the number.
Well, it's 2604-006, but I'm looking for the one where the hand's pulling down. The counsel had it. Do you remember the number? You just had it up.
I know, I'm looking.
Counsel's not being very, they don't want to help with this. There's going to be some
004?
redirect.
004.
Especially on that little, the one set of photos issue.
When you can see that.
So if there were only two people in the room, that means that was Miss Beatty's hands. Miss Betty. That's.
Do you need the number? 2604 004.
Okay, I see.
Okay, no, I think, is that your hand there?
No.
So who else was in the room, ma'am?
I only recall me and Kathy being in the room with Maya. I don't know whose hand that is.
Okay, but it's not yours, right?
No.
We said if we look at 2604-006, there's a wedding ring on the hand of that person.
Those are my hands.
Those are your hands?
Yes.
The other hand we just saw going back to 004 did not have a wedding ring, I don't believe. Right hand there? True?
Correct.
Okay. So, in the photograph, so it would appear then that you and Miss Beatty were not the only people in that room. True?
I did not say that. I'm saying that I only recall me and Kathy being in the room at the time.
Okay. There was only one set of photographs taken, right?
I did not say that. I know of a set of photographs that was taken.
Okay, but there was only one set of photographs taken, to the best of your knowledge.
Yes, that's...
This session.
Yes, this session of photographs.
And in this session, Maya Kowalski was changed how many times?
I don't recall all of the details of the photos being taken, but I don't recall there being two different sets of photos taken with me being present.
I understand. So there's only one set of photos that we're aware of, correct?
Correct.
Okay. Now, in those photographs, in this session here, how many different sets of clothing did you put on and take off Maya?
I don't remember the details of the clothing, the taking them off and putting them on, but as a bedside nurse, I would have helped her.
Mm-hmm. So there was a different set of shorts on at some point, right? You recall those photographs?
I would have to see a picture. I don't see these two pictures.
Okay. You can locate those. All right. And then we've got the pink shorts here, right? And then you testified you assisted with dressing her with a dress, was it, for court?
A dress or a skirt to go to court, yes.
Uh-huh. No skinny jeans, right?
No, I'm sorry, what was that?
Sorry. So that would be taking her out of the pink shorts and white training bra to put on the blue shorts and I guess that's another training bra, or vice versa, right? That's one change.
Are you asking me a question?
Yes, ma'am. Is that one? I'm asking if you could agree with me that that is one change that happened while the photographs were being taken, to get her from the blue with kind of floral pattern bra to the white training bra with the pink shorts.
I don't recall, as I stated earlier, I don't recall the details of the pictures being taken and the different clothes, but I don't recall putting two different sets of clothes on her. I only recall helping her put a dress on or a skirt to go to court.
Okay. Now, strike it, you don't recall actually putting up a blanket or a towel or anything to shield Maya in either of these changes, do you?
I don't recall any of the details of these pictures being taken, but I know that I take pride in my job as a nurse, yes, in my profession, and if my patient was exposed, I would try my best to protect her privacy.
I understand that. I'm just saying in this instance you can't remember whether that happened or not.
I cannot recall it.
Okay. Now, Miss Beatty, she wasn't the social worker that was regular on your floor. What was it? Something North? 7 North?
Yes.
Okay. The social workers, are they usually assigned, or did you have a social worker assigned to your floor?
We did. There were different social workers.
Okay.
I don't remember.
But generally speaking, a social worker would be assigned to a floor for a period of time?
Yes.
Okay. And when Maya was having her pictures taken, she was in distress, wasn't she?
I don't recall that.
She was crying, wasn't she?
I don't recall her crying.
She was protesting, "Don't do this. Don't take my clothes off," wasn't she?
I don't remember that.
We bring up 006 again. 006. Do you see the bit of her mouth there?
Yes.
That doesn't look like she's smiling, does it?
It's hard to tell if I can't see her whole face.
Okay. And in fact, you were holding her hands there, to comfort her and support her. True?
It appears that she is holding my hands and I'm holding her hands back. And yes, as a nurse, I'm there to support my patient.
And comfort her.
And comfort.
Now, why would a 10-year-old girl need comforting and support if all that was going on there was just taking her photographs?
I don't understand what you're asking me right now.
Were you there when Maya was readmitted after court?
No.
That would have been on at 8:18, I think, on a 24-hour clock on January 6th.
I don't remember that. I don't remember her coming back, no.
Okay. Can we bring up 1002-0249, I hope? Does this indicate that you were there on that day, the 6th, up to what, 6 o'clock at night?
Well, it looks like I charted not done, task duplication.
Okay. Maya came back before 6 o'clock at night, did she not?
I can't say yes to that. I can agree to that just by this record.
Sure.
Because it says not done, task duplication.
Okay. Thank you, ma'am.
You're welcome.
Ms. Quarles?
So now they have to try to rehabilitate the witness a little bit to say there could have been two sets of photographs taken at different times.
Can we put up, please, trial exhibit 2604007 and 2604018 next to each other, please? Does this appear to you to be pretty much exactly the same pose in both photographs?
Objection, leading. Not leading.
Overruled that one.
Thank you.
Could you repeat the question?
Sure. Is the photograph of 007, what is that a photograph of? Regarding Maya, what is that a photograph of?
It's a picture of her back.
Right. And what's the photograph of 018?
Picture of her back.
Okay. So, with respect to your recollection that morning, you have testified several times that you only recall one set of photographs being taken, correct?
Correct.
So photographs were taken after Maya came back, and after you were gone, you wouldn't know anything about that, correct?
Objection, leading. Overruled on key point.
Do you want me to repeat the question?
Sorry.
Would you know about any photographs that were taken after you ended your shift and were gone from the hospital?
No.
Even if they were taken the same day?
Correct.
Okay. So, with respect to these, they're calling it a set, but these multiple photographs with two different outfits taken that day that were produced, do you know whether or not all of those photographs were taken at the same time or two different times?
Leading. Overruled.
I can't recall. I don't know.
You don't know, right?
I don't know.
If they were taken two different times. However, okay, but you do you recall that with respect to assisting Maya with respect to getting ready to leave, that you helped her into some type of court attire?
Correct, yes.
All right. Let's talk about changing Maya. If Miss Beatty was in the room when you wanted to assist Maya with changing, what would you ask Miss Beatty to do?
I would ask her to leave, or I would take Maya into the bathroom. I would cover her up to make sure that she had privacy.
Okay, and why would you do that?
Because that's what I do as a nurse. I protect my patient.
Okay. Thank you.
You're welcome.
That's what I do. I protect my patient.
Anything
She didn't have
further,
any
Mr. Anderson?
qualms about taking the pictures
Covered her
initially.
to protect her from his beating, correct?
Objection, Your Honor.
I don't recall the exact.
Sustained.
None further comment.
Members of the jury, do any of you have any questions?
We're going to see how many questions they have. It's just a few.
Why don't we try to do this at the sidebar?
They said they're gonna try to do it at the sidebar. Oh, you heard that part. So you heard it in this year. So you heard all that. So we're not going to hear the questions at this point. Unless everybody stands up. And I'm not seeing them stand up. All right, we're going to see what the jury thinks of this in their questions here. At least the ones that get through the screening process that's going on at the bench right now. Here's what I'll say, Carolyn. I think the jury is not going to be hostile towards this witness. She has not been hostile. Her mannerisms, the way she answers the questions. She has not been like standoffish at all under cross. She's tried to answer everything. She's been a little confused about some of the questions, and I think even though the questions were sort of plain English, I think she was confused as to what they were getting at more than what the words meant. So I'm going to give her some space there. This is probably the first time she's ever testified in court. So I don't think there was anything about this witness that was deceptive in how she was answering. I think, honestly, she doesn't remember. I think Mr. Anderson did sort of trick her a little bit into saying there was just one set of pictures and all this happened at the same time, and her not having a recollection of it happening at different times. She sort of admitted that must have been that way because I can't remember a second set. It helped for him for Mr. Anderson to be able to pull out that basically the medical record that had her showing that she was working till 4 p.m. that day. Maya would have been back before 4 p.m. if she left in the morning. 4 hours in court, that's a long time for a dependency hearing. I don't think it went that long. Apparently, I don't think it would have brought it up if it had gone less than that. But so they're going to ask some questions. I think it's going to be related more to Miss Beatty and whose hands, and that it's concerning if there were only the two of them in the room that Miss Beatty appears to be prying at her clothes or pulling at her clothes to expose an area of the body to take a picture. That's concerning. The fact that there were only the two of them in the room, there wasn't another doctor asking for pictures or being there to take pictures. And the fact these didn't end up in the medical file. Wow. Can we hear jury questions? Rona, I can hear them when the judge sends the jury and the witness out of the room. Bailiff's back there waving papers like he's bidding on an auction. I'm not sure what's going on here. Oh, more questions are coming in from the jury. That's what's happening. He's delivering more questions. Redtail says, all right, agree to disagree. Miss RN with master's degree played the dumb card well. I didn't see her playing the dumb card. I see her intimidated with being in court, and I realize I like to try to give people room for understanding. So I'm trying not to be judgmental. Yes, there are some questions I thought were very plainly worded that she said I don't understand, or can you restate that? But I don't think it was hostile. Her mannerism and everything, I think it was good. I see you now, gifted 5 memberships. Thank you very much. I see you now. And Catherine Fallon, welcome to the gallery. Welcome. Thank you so much. As well as those who just got gifted memberships. CG in Texas also was gifted a handful of memberships as well this afternoon. Thank you very much, CG. Appreciate that. It's very generous and kind of you. Will Maya be on the stand again, yes or no? I think the answer is no on that one, Brad. I don't think they'll put her back up. I don't think they have any reason to. Who was taking the pictures? I'm surprised they didn't ask this. I'm surprised if they could ask the nurse, did you take the pictures? Was it your phone? And if it wasn't, I mean, I guess in theory, Miss Beatty could hold the phone in one hand and use her other hand to position Maya. But interesting stuff. Let's see. Keith Barrett, welcome to the gallery, my friend. Thank you so much. Mandy McGinnis, welcome. And Lacey Ann gifted a membership as well. Thank you all. I appreciate your support.
Okay, members of the jury, in amongst the questions, there was a question about the dependency order instruction I gave you. What I'll tell you is I will give you the dependency order and what I'm able to say in the final package. I understand there was a question, but it will be what it is in the final package. Now, nurse, is it Alcide?
Yes.
Okay. Do you know if Maya's parents consented for the photographs to be taken?
I don't recall that.
Did Kathy tell you she had obtained consent?
I don't recall that.
Did the photographs get placed in Maya's medical record, or do you know the purpose of these photographs?
I don't know if they were placed in the medical record or not, and I honestly don't remember why the photos were taken. I just know they needed to be taken before she went to court that day.
Next question. How many bedside nurses were assigned to a room during the 7 a.m. to 7 p.m. shift?
How many nurses were assigned to
a room during the 7 a.m. to 7 p.m. shift?
One nurse per room.
Okay.
One nurse.
And there was a question to the court that I can't answer. Next question. Is this timeline and clothing correct? Helped Maya get down to shorts and white bra. Is that the first step?
I don't recall the exact clothing and from my memory of the clothing that she wore for the photos. But in the picture, she was wearing the white sports bra and the pink shorts.
Okay. Then the photos were taken, and then you helped Maya into the dress?
I don't recall. I'm sorry, I don't recall the exact details of the photos being taken. It was many years ago, but I do recall being there as an assistant witness to help her to take the photos, and I remember helping her into a dress or skirt of some type before she went to court.
Was she in the same bra, or was her bra changed?
That I don't remember.
What color was Maya's court attire that you helped her change into?
I don't remember.
Ms. Croyles, that's the conclusion of the jurors' questions.
Nothing further on.
Mr. Anderson.
Just briefly.
Trial Exhibit 2604-5.
Those pictures are missing metadata.
Was that the shirt that she came in with?
I haven't seen this picture before.
Came in.
Well, when you came in, was she wearing that shirt?
I don't remember what she was wearing. I don't recall what she was wearing.
Does that look like a happy child to you?
No, she does not look happy.
Thank you.
That was one of the pictures that was taken during that photo set, or one of those photo sets.
Nothing further, Your Honor.
Members of the jury, any further questions? Will this witness be excused and released from all subpoenas?
Yes, Your Honor.
And thank you for being here.
You're welcome.
I'm sorry?
Is it the deposition next? Trying to remember.
Judge, this is the third time lucky or 3 strikes you're out, but we're going to play Dr. Malik. We've tried twice to do.
This is the depot with the blue background.
I think it's shorter even now because I don't recall. 50 minutes. We cut off another 5 minutes, Judge.
That sounds like an 8 minutes and some odd seconds.
Yes.
So now that you know that it's 50 minutes, do you want a break or do you want to do the deposition first? Seems like the majority says do it.
Maybe we approach for 1 second then.
Sure.
The judge had an audible sigh. Okay, so this is, you're going to see a depo that you think you've watched 50 times in your sleep. Okay, we've seen this. This is like the blue backdrop testimony that we've watched over and over. And every single time we've watched it, there's been an objection partially through, and they've stopped playing it. The first time the plaintiff has made an objection saying, hey, we've tried to change our designations on this. This is playing too much. It's eating too much of our time. The second time, Ms. Carell's stopped it and said, hey, we've got a problem. It's playing something it shouldn't be. Now we think we have the final version, but we're going to watch it. It's 50 minutes long. So apparently there's something super important that we need to see in this. Looks like everyone's standing. The jury's leaving. On Zoom, the jury's walking out. Let's see what's up here. Oh, you're going to hear too.
Okay, the jury's out of our presence. Mr. Anderson, I think the phrase you're looking for is we are proceeding at impulse speed and not warp speed at this time.
You took the
5-minute break, and we're going to get the clip report. Thank you.
So we have 5 minutes, a 5-minute break. They're going to do one last final edit on this little video before we start this deposition. Right now it is 50 minutes, 50 minutes long. And I would reckon that most of these minutes that are going to be on this deposition are going to be defense designations, meaning that it may be Mr. Anderson asking the question, but it's a part that the defense wants played in front of the jury, so the time will come off the defense's time card. So watch for that. Renee James, welcome. I saw also we had Peter Steele coming in. Amy M., did I catch you already? Welcome to the gallery. Thank you so much. JM says, Sally Smith, child protection is an honorable role but dangerous when being done by a dishonorable person. She has had her own agenda. Sad. Yeah, I'm still waiting. I still need to cool down a little bit before I can maybe talk about that. Okay, so we're going to replace the pinned message. We went from the nurse to, we're going to go to Dr. Farhan Malik, who's a critical care pediatrician, and it's a 2019 depot. This is going to be chopped up. It's going to be rough unless they've fixed it since last time. It's gonna be like cut and paste, like they took every 5 seconds of the video and cut them in clips and then glued everything back together. It's a rough deposition to watch, and it's nearly an hour long. See, I don't think Jules can give us a recap in 5 minutes. That's quick for her to run out of the courtroom, contact us, and get back in time for testimony. So she's probably staying in there for that. I think people forget all these witnesses are testifying about what they remember about something that happened 7 years ago. It's impressive that anyone can remember. I have a hard time remembering what we did yesterday. I don't know what I ate for breakfast. That's the truth. I will tell you that over lunch we opened up the Halloween candy because, why not? You have to test it, right? You can't just be giving out candy. You want to make sure the Snickers are still good and the Twix and everything else is still good. And so we've opened up the Halloween candy. And I don't know what happened between last year and this, but Fun Size is a little less fun this year. Like fun size used to be this, and it's small. It's a small change, but it's like 1 centimeter just got cut off the candy bar, and it's distressing to me. It's distressing. You guys, when you get your Halloween candy, I don't know, all of you do the parent tax. I do the parent tax as well. It's one of the benefits of having kids and send them out gathering candy on Halloween. But when you do the parent tax, find your favorite candy bar, and you'll probably remember from all the previous years you stole this from your kids, but find your favorite candy bar, take that and measure it, and just see if it got smaller this year than it was before. A little less fun. Anyway, we've eaten so much of the candy, I think we need to go to the store and get some more. We're not going to have enough this year. I got my Mountain Dew. Unfortunately, I have this much left, so hopefully that'll get me through the deposition here. That's usually when I get a little sleepy. K-Cat says, if Maya was voluntarily taking pics, why would they need to hold her hands out? K-Cat, yes. Why did she say I'm holding her hands out to the side? Okay, and Mr. Anderson was generous of saying to comfort her. Okay, but why are you holding her hands at all unless it was an involuntary position for the child to be in? Why would you be there at all? If she was like, okay, cool, we're going to go to court. A few pictures, sure. Take the pictures, I'll get them done, I'll get me to court. No, she was like curled up in a ball. This is a defensive move when your hands come in. It's like a fetal position. And why would you be holding her hands at all if she was just happy and going along with it? Mary Murphy, welcome to the gallery. Thank you for your continued support. Over 6 months of support there. Thank you so much. They had her pinned down. Yeah, the pictures, I mean, we're not talking like a wrestling pin where someone's, on the mat and they can't move and 1, 2, 3, you're out. Not like that. But yes, definitely she was being held down for photographs. Held in position so she could be photographed against her will. I think the picture speaks for itself like that. And to try to say that anything else happened other than that, especially when you've got the other pictures in that set, including how sad she was. Her face, yeah, you can't see her whole face, but you can tell the child's not happy. Maya was not in a good space there. She was not happy with what was going on. Let's see. I personally, myself, I believe there were 2 sets of photographs. I think it stands to reason there would be 2 sets. I don't see back here when this happened that Kathy Beatty would be saying, okay, now we need 1 set of pictures with her in this clothes, and they'll change her clothes again. Now we need another set so it'll look like we did at separate time. I think there were 2 sets. This nurse got tricked a little bit into saying there was 1 photo shoot, and I guess this all happened at the same time. Her memory's not clear on that, but. Jan, I'm trying to find a solution for making the super chats a little bit better, especially when you have a bright background and the colors. I can't choose the colors on super chats, so I might have to find a different software tool that helps me do that. Corell's just asked for Advil because she has a headache. Mrs. Lawrence offered her some. I'm not sure. Is that what happened? I think it would probably more witness or evidence related because Miss Lawrence handles a lot of the evidence, the stamped numbers and different sheets and things, and Correll's does the same on the other side. Someone was asking earlier about is there a roster for the teams to see who's on each side, and we can sort of walk through it a little bit. I don't remember who has the Alienware the laptop in the back, the gentleman in the back corner. He is their video guy. So when we want a exhibit put up on the screen for the defense, he's the gentleman that chooses it and puts it up on the screen. Then next to him is Ms. Lawrence, who just got her, just passed the bar. So she's a full-time attorney now. Ms. Lawrence is helping with evidence. We've got Mr. Edelgate. I can't remember. He's the appellate attorney for the plaintiff. Mr. Anderson and Mr. Whitney.
And are we okay?
On the other side, sorry, I'm running out of time. We'll have to do this another time.
Doing that, Judge, I had a question. I would dearly love to bug out, but we had that one issue about the pharmacist shot, and it's being held for 2 purposes.
You want to deal with it now while this thing's being printed?
Yes, that would allow me to get out of here.
2 left hands in the photo. I thought I saw a thumb that would make it a right hand. It was barely visible.
What's the issue?
Thumb on the right hand.
The issue, you may recall, Judge, that there was an issue about a particular prescription that said terminal on it, or
patient is terminally ill.
Right.
I thought that was out, and we're
Exactly.
dealing with it.
That's exactly my point. The other part, I don't think is a problem with it, but the court's already ruled on that, and I didn't want to have it sneak in someplace.
Your Honor, we're okay with, we know that patient is terminally ill is out. We would still like to move the prescription in as a medical record without the patient is terminally ill designation at the bottom.
Not to, I know you don't like tag team.
This goes also to the IV ketamine?
No. The prescription is for a number of different opioids, and it would refute Dr. Kirkpatrick's testimony.
Put up the prescription, please, so I can actually see what we're talking about.
This just in through Brian Etten on Twitter.
The argument would be
the BK case. The judge might ban cell phones too.
Written by Dr. Kirkpatrick during the proffer from Mr. Hunter, he agreed this was a prescription he validly wrote. The 403 objection is just over the terminal sense. They're not arguing that a prescription written for this patient was invalid. It was sent to the pharmacy to be filled. The reason why the defense needs it, besides just being a medical record, is it goes to our theory that the medications being prescribed prior to this, they jumped right to heavy-duty narcotics to dispute what Dr.
You're telling me it has nothing to do with IV ketamine?
Not a correct.
It has to do with IV Dilaudid.
Well, I'm just...
Yes, it's 3043.
I'm still waiting for it to be put up.
3043. And there was also a PCA pump to administer that Dilaudid. That's one of those pumps that a patient can click and self-administer.
Whitney tells Anderson, I can take this if you want. I can take this if you want.
You'll notice the date of this is November 5th, 2015, after several rounds of ketamine. It also goes to show that the ketamine treatment that Dr. Kirkpatrick is extolling is not working.
And isn't this the medication to get us, or get Maya to Mexico?
Yeah.
What did I do with, because didn't we keep out all of the, I'm trying to remember what the ruling was with respect to the comments back and forth about this issue.
So far, you've kept out the comments on terminally ill. We'll redact patient is terminally ill out. We can redact the whole scribble below. We just want the prescription in to show that the medications are being written. It goes to the extent of how sick she was and how much pain medication she needed as she was going to Mexico. So we can redact below the signature line if the 403 objection is patient is terminally ill, but we need the date of the script. Yeah, and Mexico is not for another 3 weeks after this, so it goes to show how poorly Maya was doing that time frame. It all goes to the defense theme to contrast to the plaintiff's argument that this was a miracle drug and a freight train heading towards college, and here we see, morphine. So, the 403 was just for the bottom comment, and we would agree to take up the bottom comment. Perhaps we may not need a witness on this issue. I don't know if there's anything else Schott is being called for.
Schott's there just to talk about this prescription as well as the Dilaudid PCA pump and the accoutrements associated with it.
That's Mr. Hughes' voice off camera.
I honestly don't know the answer to this question, but I don't know that this prescription was ever filled. In other words, there was this issue over the insurance company, and the pharmacist was writing this on there, this terminally ill comment, in hopes of getting this filled. And I think there was some back and forth about that. Those are the comments Your Honor's excluded. And I don't think it ever manifested.
Here's where I'm at. Here's where I'm at with this. This case isn't about the specific medicine in 2015. There's already been a ton of testimony about the various things that she did have. There was testimony about interval medicines to get her to Mexico, and it almost seems like that this, I've talked about the terminal ill, so even if we were to redact it, I don't know what this does for this particular case, it's either cumulative or if it's being used for some other purpose that is a backdoor for something, then in that regard it'd be a 403. So I don't see.
I'd be happy to articulate. And for the record, when we say we're agreeing to redact patient is terminally ill, that's based on the prior court's ruling. We're not waiving the fact that we believe that's relevant. The reason why this prescription is relevant is because it goes directly to the heart of the defense case that all of these medications were required for Maya Kowalski to keep her from having this exquisite pain. The plaintiff has put on a case, and again, the most memorable witness of all was Robert Tremp saying how well Maya was doing. She was a freight train headed to college. The ketamine was working. How dare you interrupt the medication regimen for this patient? And what this shows is Maya's condition before. They are accusing All Children's Hospital of either causing or aggravating her condition because we interrupted the medication regimen. This is the and this is a very, very important record for the defense because it shows extremely significant opioids that the prescribing physicians were given this patient. The plaintiff has put this front and center in their opening argument that all of this, what was going on before All Children's, was mild, not a big deal. She was thriving. Look at her in the pool. She's doing well. And then they want to contrast that with, you had no right to stop at any of these medications. She was going to be doing great until what you did on the wean. And that's why we need to give this jury a very honest picture of here is all of what Maya Kowalski required. I respectfully can't see how just a prescription written by Dr. Kirkpatrick in real time for significant opioids to address her pain wouldn't be relevant for the jury to understand the before and after. I don't see how a prescription would be prejudicial.
Yeah, well, I know I made a comment about this in written order 4 or 5 months ago, but it seems, and both sides do it, that the number of adverbs and adjectives and the hyperbole as to every single issue makes it more and more difficult to differentiate the true important issues versus what you want and are just trying to use hyperbole. This is a time period before the ketamine coma, a year before the admission of Maya Kowalski. And so it seems to me that we don't need to put every single piece of paper, especially when there's already been testimony that she had lots of drugs and needed more drugs to get her to Mexico.
Dr. Kirkpatrick said the exact opposite in his testimony. Dr. Kirkpatrick's testimony on this was that he exhausted all conservative management before he finally sent her to Mexico, and this contradicts his testimony on that. And respect, I will say to the court that the defense would consider this piece of testimony about these significant opioids and with the terminally ill, but I understand your court's ruling, and the IV ketamine being given at home as 2 of the most 5 significant pieces of evidence in the defense. I apologize if there's been hyperbole.
I think we've got at least one objection in here.
It's a prior medical record of a plaintiff in a medical malpractice case showing the extreme difference before.
Was this filled?
I can double check that for Your Honor, but the fact that Dr. Kirkpatrick signed a prescription where he is authorizing under the law in his FDA license that he believes it is medically necessary for Maya Kowalski to have hydromorphone PCA pump on a 30-minute lockout due to her extreme pain is absolutely relevant to the case, again, to show the before, because if they're going to accuse All Children's of aggravating a pre-existing condition, we need to understand the pre-existing condition. I can find out whether it's filled, but there's no question Mr. Hunter proffered Dr. Kirkpatrick, did you write this and did you sign this? And he agreed this is a valid prescription. So it at least goes to the fact of whether Dr. Kirkpatrick thought that these doses of hydromorphone through a PCA pump were medically necessary to control Maya's pain.
And it's so important we don't know if it was filled.
Well, we can ask Dr. Shaw whether it was filled. I believe it was.
Then wouldn't the pharmacy records have it?
Yeah, as I'm speaking,
Are the pharmacy records in?
Are the pharmacy
searching them right now?
Mr. Hughes is looking for those right now.
Because if the pharmacy records are in, then...
Judge, why don't we just ask the witness? I mean...
Because then you can present it in front of the jury.
I feel like we're getting cut off at the knees here with this stuff based on some value judgment of perceived importance on the court's part, and it goes to the jury with the weight of the testimony. If it's not filled, then fine, we can deal with that. But we believe it to have been filled, and if it was, it's a significant piece of evidence regarding the pre-existing condition of this patient.
Apparently, we're going to discuss this. The doctor right there in the red shirt with the gray jacket, he is the representative from Johns Hopkins. I can't remember his name. That's not Elliott, is it? I think it might be Dr. Elliott. He's a representative today. He was a witness as well, but he has been here several days, standing in as a representative from the hospital. Panning the room here, I think Jules has stepped out. I see Jules has stepped out. We just have Jack present from the family. Two people right behind Jack are audio and video personnel, I believe. Angie Carter, welcome to the gallery. Thank you. Thank you for your continued membership. Love to see that courthouse color change next to your name. Megan Dayton says, my special needs child has 3 or 4 medications that are in the house and refilled once a year just in case. I don't feel like this matters. I think... if I remember correctly from the discussion before, this same point of I don't think this prescription was filled was raised, and the same thing is, we can check into that. We'll look into it, and nothing happened, which I believe there's no evidence that this prescription was filled, and they're not going to find it. That's why they're continuing to argue the different angles. Let's just ask the witness. Let's just bring it up and ask him, was it filled? And if it is, then we can talk about it. If not, then we'll move on. But it sort of gets them to present this to the jury anyway, which they really want to do because this is a strong prescription for some powerful drugs. Why would defense want to show that Maya was in severe pain to need that med? They want to show more that the doctors were prescribing, in their mind, scary amounts of drugs, scary amounts of very powerful drugs, and that would go to the med mal. Not the med mal, excuse me. That would go to the medical child abuse claims. And saying this is what we observed was going on. The family was doing this, even with the doctor's orders. They happen to have a photocopy of a filled prescription. I doubt it was filled. Yeah, I don't think it was filled either. Let's see. Travel can cause a flare. It's responsible to take emergency meds. And this was designed to be filled so that she could travel and not be in pain. Did he just go to a sidebar to yell at the lawyers? Jamie A., possibly. We can't hear. He is standing up right now. I'm looking at the Zoom feed. See, I can't see any faces. Everyone's standing so close to the desk now because it's so hard to hear. We just see suit coats, and it looks like somebody just left. Carell's is still up. Shapiro's still up. Whitney's still up. Judge is still standing. I think Hunter's there. They're all still up there at the desk. A little bit of movement now, but I think they're still up there. Why state she was terminally ill to have the prescription filled? I think that what the defense is trying to say, that this level of prescription for this particular drug is more typically seen in patients that are receiving end-of-life care with severe conditions, and so the prescription, which would possibly be outside, and I'm just speaking of what I've heard in court and argument. I don't have any personal knowledge of this. The prescription amounts, the dosage was such that the patient that basically they were told this is how severe it is. It's like it's the end of her life. I'm speculating here. And that note was written on by the pharmacy rep or something, who probably looked at the prescription and said, "Whoa, that's a little big," and called the doctor and said, "What's up? What's up with this prescription? Is this on the up and up?" It doesn't mean it was given, or even it wasn't, or all given, even if the script was dispensed. Former pharmacy tech here. I love that we have experts in every field here. It is so cool. Created by EJF says, if that had been filled at my pharmacy, the pharmacist would have to at the very least initial the front of it with more writing or info on the back. So this is basically what you're saying is this would be something that would set off a red flag, at least something that needs to be looked into before we just fill it and hand out a prescription that is potentially dangerous. I'm not sure on objection count if we missed a couple. If you guys let me know if that number needs to be a little higher than what it is now, I'll update it. And speaking of objections, let me put on the screen where we are as far as the guesses go. Let's see. We're way back. Counting down. Lots in the 1700s. Let's see. Here we go. Hopefully you didn't get whiplash from that quick. There we go. Debbie Wilson, Katie B, Lee, Moxadia, Cielo. I think you're in the lead right now. Hope 8 Fear, Dale, Franco. That's where we're at right now as far as the guesses on the total objections throughout the end of the court. At least up till closing arguments. We just got an Amber Alert. Haywood County, Gray, 2020 Jeep Cherokee.
Okay, let's bring back the jury.
Jury's coming back in.
All rise. Jurors entering.
Thank you, Princess Buttercup and Rebecca. Appreciate both of you. It's Rebecca's credit card. Princess Buttercup is the one using it.
Okay, please be seated. Now you probably feel like my wife does when I say 5 minutes. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And no one has approached you in the last 5 minutes? Correct. And you haven't seen any media accounts. Is that correct? Correct. Ms. Corrales.
We'll call by deposition Dr. Farhan Malik.
Do we want the lights to be as is? The majority says to keep light.
This is the blue background. We've seen this before. 50 minutes, guys. 50 minutes.
Raise your hand, please. You solemnly swear that affirm the testimony you have to tell the truth, the whole truth, and nothing but the truth.
Yes. Please state your name for the record.
Farhan Malik.
And you are a physician in practice employed by Johns Hopkins Children's Hospital?
Yes.
And where did you go to college?
New York Institute of Technology.
Year you graduated?
2005. 2005. Yeah.
Medical school?
New York College of Osteopathic Medicine.
This question's very informal.
And where's that located?
It's also located with New York Institute of Technology. They're both in Long Island.
And what year did you graduate your 4 years there?
2009.
For the benefit of the jury, can you give them a very brief description of the differences, if any, between an MD and a doctor of osteopathic medicine?
Sure. The degree is actually called a DO.
Yeah.
It essentially is very similar to MD schooling. You just take additional courses in osteopathic manipulation, which I liken it to chiropractic. And so you have the option of practicing that when you graduate versus just practicing as a regular doctor.
Again, I don't know how accurate this is because I'm just reading off the internet, but osteos tend to be literally more hands-on with the patient. I mean, there's more manipulation and testing, feeling, touching, that kind of thing, and diagnosing.
You take classes in the manipulation aspect of it, and if you choose to practice that, once you're done, and incorporate that into your practice, if you're in a field where you can, such as internal medicine or general practice, becomes a little different when you become more and more specialized.
The area that you chose to go into was critical care with a focus on cardiac, is that right?
Yes, cardiac intensive care.
All right. And where did you do your residency?
Newark Beth Israel Hospital, so the Children's Hospital of New Jersey.
And what year did you, what years were those?
So that would be 2009 to 2012.
And after residency, what did you do?
I did my fellowship in pediatric critical care at the University of Texas in Houston.
Right. And what year were you licensed to practice medicine in the state of Florida?
2015.
So at the time you saw Maya Kowalski in her October 7th admission, you had been a licensed physician in Florida for 15 months. So you made 12, May, June, July, August, September. So about 16, 17 months?
Yes, I believe, approximately.
You were a fairly young doctor, relatively speaking, experience-wise?
Yes.
Were you licensed in any other states?
New Jersey.
And what year were you licensed in New Jersey?
That would be at the start of the conclusion of my residency, so that would be 2012.
So after your fellowship at UT Houston, where did you go?
Johns Hopkins Children.
And what was your position?
Pediatric critical care physician.
And what does a pediatric critical care physician do?
All things involving intensive care. So if a child gets admitted to the ICU for any number of reasons, trauma, sepsis, after surgeries.
Would it be fair to state then that as of October of 2016, you were not an expert in complex regional pain syndrome / also known as RSD?
Yes, that's very fair.
Would it be fair to say that as of October of 2016, you were not an expert in medical child abuse?
Yes.
You were not an expert in factitious disorder by proxy?
Yes.
You were not an expert in a conversion disorder?
You're listing a lot of psychiatric disorders that, no, I am not an expert in because I'm not a pediatric psychiatrist. So.
Okay. And then Munchausen by proxy, same answer?
Yes.
Not an expert in that either. All right. When was the first time you met Dr. Sally Smith, if you recall?
I don't believe I've actually ever met her.
Have you ever spoken with her on the phone?
I can't recall exactly, but I might have spoken with her regarding this case.
Did you know of her, even if you didn't speak to her or see her?
Yes.
And what did you know of her as of, say, the period before October?
That she was our go-to person to speak to if you had concerns of child abuse.
On any of Maya's prior admissions or visits to the ER at ACH, had you ever run into either her or her family?
No.
So the first time you ever met any of them would have been on that October 7th visit?
Correct.
And do you know Dr. and I'm going to it's Tepes Sanchez, but I think everybody just calls her Dr. Tepes. Is that right?
Correct.
Okay. Did you know Dr. Tepes before this admission?
Yes, we're colleagues.
And how long had you worked together?
A couple of months.
What were you told on the phone and by whom?
I received a phone call from the ER attending, Dr. Posey, about essentially Maya coming in with these complaints, the requests of the family, their inability to perform any radiologic studies like a CAT scan because there were complaints of abdominal pain, and her inability to really do anything substantial to help, and the request for an ICU bed so that we could treat the pain symptoms.
But did you have access to this record by the time you became more involved in Maya's care?
Dr. Tepes' record?
Yes.
Yeah, once it was input into the system, then if I needed to refer to it while I was taking care of Maya, yes, I would have had access to it.
When was the first time you ever actually met Maya or any members of her family?
That Friday night. Once she got admitted. Well, the case was unusual, and it required a lot of prior planning. And so Dr. Tepa and I, especially because we knew that multiple care providers would be seeing her throughout the weekend, got a sense of what was going on from the family and Maya. And so that Friday night, even though she was the one taking the history and putting in the orders, or her team was, Dr. Tepa's team was, I made sure that I familiarized myself with all the ongoings so that I could respond if a problem arose.
But it did make you aware that she was being treated by Dr. Barr, a neurologist in Orlando, right? Followed by Dr. Barr, fourth line down?
It made me aware that she received treatment from multiple providers, which made me concerned enough that we should treat her symptoms as significant, and we shouldn't dismiss it. And actually, I recall distinctly saying that we need to approach this like complex regional pain syndrome, because there's no evidence that this isn't complex regional pain syndrome and that she isn't having a pain exacerbation. If I recall distinctly getting up in front of the ICU and speaking to multiple nurses who were concerned and other care providers like nurse practitioners that were concerned about our approach in delivering this amount of ketamine and this amount of propofol and Precedex without the same type of monitoring that we normally do in patients who get this type of medicine, things like arterial blood lines, which measure blood pressure, continuous oxygen saturation. In reading all this and have gotten a cursory history, hearing about all of it, I knew that we should approach this as if it's real, which it could have well been at the time that we got presented with her.
When was the first time you personally spoke with any of her prior treating physicians?
I didn't speak personally with any of her prior treating physicians.
No one related to you anything about why or her history with that doctor in Clearwater?
No, just the diagnosis of complex regional pain syndrome and the need for ketamine.
And found it. Documents here, Dr. Hannah was contacted by our EC and stated she received 1,250 milligrams of ketamine with 50 milligrams of 2% lidocaine, 750 milligrams of magnesium sulfate, and 4 milligrams of Versed, right? Fairly potent pain relievers, a couple of them there, right?
Absolutely.
Abdominal ultrasound and abdominal CT were ordered, but mom refused these studies, stating she wanted the propofol to have started prior. So mom didn't refuse those. She wanted the child to receive pain med before she had that kind of testing?
Yes.
Were you aware that both a PICC line and a port were surgically placed in Maya at All Children's Hospital?
Yes, I was.
And one of the purposes of the PICC line and then port was for ketamine infusion?
Yeah, I was aware that the PICC line and the port were placed, yes.
And one of the purposes was for these infusions?
Yes.
And so, did you speak with the surgeons and anyone involved with those procedures?
No.
Did you speak with Dr. Kreisman in endocrinology at ACH about his experience with the patient?
No.
Did you speak with Dr. Jackman in endocrinology about her experience with the patient?
No.
What doctors who had followed this patient in prior admissions to ACH did you speak with at this time, October 7th through 9th, let's say?
Once again, it wasn't my patient. I was taking care of her adjunctively with Dr. Tepa Sanchez, so I didn't speak with any of the physicians.
Do you know Dr. Tepa Sanchez did insofar as any conversations you recall having with her?
The only ones that I was aware of, like was mentioned in this note, was Dr. Hannah.
Can you expand a little bit on the instructions to the ICU, or maybe it's ER team, I'm not sure, about treating this as CRPS? What in essence did you tell them?
What did I tell the ER?
Well, you said you got up in front of the
ICU.
Sorry. In front of the ICU. What did you tell them about, other than this is CRPS and we should treat it as such? Anything else you said to them you remember?
Well, the concern was that she was in a lot of pain to the point where we couldn't apply a blood pressure cuff, take vitals. Part of being in an ICU is frequent vital monitoring, especially when you're delivering a lot of these heavy dose medications and stop your breathing, lower your blood pressure, lower your heart rate. Given the uniqueness of the situation, but our inability to know, otherwise that this isn't CRPS or to keep treating it like it, I essentially got up in front of the ICU. I said, we have to treat this like CRPS, and we're going to try to monitor her with the best of our ability, and if we see signs where we feel like the medication is slowing down her breathing, or if it's affecting her blood pressure or messing with her perfusion, then we stop. But otherwise, we treat this like we're being asked to treat it.
Was there any resistance from any of the staff about treating this as CRPS?
There were concerns. I remember nurses being very vocal. I don't recall which nurses or what was said, but I just remember it being a very heightened emotional environment.
What were they vocal about?
The situation where this amount of dosing for these medications without that invasive monitoring and without that frequent monitoring.
Did you ever speak with Maya this first day?
She was in so much pain that I couldn't speak with her.
Who was in the sit-down from the Kowalskis? Jack, the father?
I think it was both the mom and the dad. Yeah.
And in this meeting, were they open to your suggestions?
Yes.
How would you describe the meeting? Was it professional, cordial? Was it confrontational? What was it?
The very first meeting was professional.
No raised voices, no accusations, nothing like that?
No.
At this point, then, had you examined Maya yourself? Or
Well, I couldn't examine her because she was in a lot of pain, so she wasn't answering any questions. She wouldn't let anyone touch her.
But the nurses don't set the course of care or diagnose, do they?
No.
So you were following what Dr. Hanna had prescribed with the exception of the ketamine dosage?
We were following what we thought could help alleviate the severity of her pain symptoms. I don't believe Dr. Hanna was giving her propofol.
Okay. All right.
And so we took her pain symptoms as being so severe that she needed to be basically induced into anesthesia.
Pain team, including Dr. Dolan and Dr. Elliott, were you included in that part of the conversation?
Yes.
What did they say, by the way, about CRPS, her possible sources of her pain? If you recall.
From what I recall, they wanted to treat it like CRPS, and were aware that she was receiving outpatient ketamine infusions, and were aware that she had undergone treatment in Mexico, and therefore we came up with, as a group, the dosages that we came up with.
Anything else you recall from this part, this first evening, and I guess what is contained in Exhibit 2? Anything else?
I mean, just that, once again, we approached this as a team, which included the nurses, the physicians, the pain management team, and my concern was that we approach it to the best of our ability like a diagnosis of complex regional pain syndrome.
Was the idea here you'd start in like all the concerns over monitoring, you'd start out with a lesser dose, see if it worked, didn't work, and then up it if necessary?
Yeah.
And that's prudent medicine, right?
Yeah.
See what works.
Yeah.
Right.
You go low and you go slow.
You told them, how many days did you tell them you expected her to be in there?
I don't recall.
Was there any limit in your mind?
There was, I believe, a plan that we came up with. And as soon as she would have been off those medicines, then she would have been transferred out of the intensive care unit to a less acute unit.
Off of those medicines? What do you mean off of those medicines?
Off the continuous infusions.
Not off ketamine, just off continuous infusion.
Yeah, continuous infusions can only be administered in an ICU given our resources, our ability to frequently monitor, our nurse to patient ratio. Once she was off those infusions, continuous infusions, she would have been transferred to a less acute floor.
Tell me up to this point how many times you had seen Maya Kowalski.
So she got admitted Friday night, and then Saturday I was there, involved once again along with Dr. Tepa Sanchez, and then Sunday I believe I was on call 24 hours, and so I'd seen her approximately 4 to 5 times.
4 to 5 times, and for how long each time?
Each time about maybe 5 minutes, 10 minutes.
All right, so somewhere between 20 and 50 minutes total.
Yes.
And how many discussions had you had with Beata or Jack Kowalski at this point?
At this point, I had, I think, 3.
And where were those discussions?
They were mostly in we have a conference room, so outside of the patient's room.
On which floor?
Same floor.
On the PICU?
Yeah, inside the PICU.
All right, so tell me about the one on Saturday.
Saturday, I don't think involved us sitting down in the conference room. I believe it just involved us outside of the patient's room.
And what was the topic?
Topic was how is she responding?
How was she responding?
Not very well. There seemed to be no mitigation of the symptoms.
And so what did you discuss?
On Saturday, that we would continue the same treatment plan, but that most likely we would be coming down and completely stopping by Sunday, since we didn't see any change in symptoms.
And why not increase back up to where the physicians that had been following her for a year or so?
Because I believe she didn't want to be intubated. She didn't want the breathing tube, nor did we want to put a breathing tube in her. And we weren't comfortable going up on these medicines without securing her airway.
All right, so there's a pain management consult, is that right?
Correct.
Have you ever seen anything in writing about that?
In regards to Maya?
Yes, from pain management?
No.
Well, what did they tell you, and who told you?
Pain management told me that they didn't feel comfortable going up on her medication, and we expressed the same concerns given the lack of an airway, and that was the discussion.
Who said that? Dr. Dolan?
I can't recall if it was Dr. Dolan or Dr. Elliott.
You were not an expert in ketamine infusion for CRPS, were you?
I am not, but I deliver ketamine as an intensivist for post-operative pain and for procedural sedation.
So I'll just ask this way. You had a different view on the appropriate dosage for ketamine than Maya's attending physicians outside the hospital. Fair enough to say?
Different in the fact that we were not comfortable delivering the same doses that she had been receiving without standard things that we would do, such as putting a breathing tube in, putting a arterial line in, becoming a lot more invasive with the patient. So that's where we, at least personally, I disagreed with Dr. Hanna and the other physicians that you mentioned.
Okay. Those physicians had more experience with this patient, did they not?
I can't speak to their experience with her. I can just speak to what I was presented with and my inability to invasively monitor her, both at the parents' request and at our request, because we did not want to undertake something that could potentially be lethal to treat this pain.
So we had and what did the parents say here?
They didn't want her intubated.
Okay, and did they state a reason why?
I don't recall a specific reason. I just think that, just like anyone, you weigh the risks versus benefits. And the risks of her undergoing anesthesia and getting a breathing tube for who knows how long versus the benefit of alleviating this pain, it didn't make sense to them or us.
Okay, so you then said, all right, well, we can't serve your purposes here. We don't think it's a good idea. It's against our recommendation, but, you know, see ya. Bye.
No, we We agreed upon an acute care plan, which were the doses of ketamine, propofol, Precedex, all the while trying to figure out a source of her abdominal pain, trying to get her a CAT scan of her belly, making sure that she was getting nutrition.
Are you saying the parents did or did not want her intubated?
If I recall, they did not want her intubated.
And now Dr. Patel did not want to intubate her?
Yeah.
Did you discuss this with Dr. Patel?
Yes.
So, on one hand, the Kowalskis have one attending, and you were an attending physician too, Maya, right?
Yeah.
One attending physician who's saying, I'll consider increasing the dosages here, try to give her more relief, but I'd like to see an intubation, right?
If I recall the context of the discussion, which it was always the case from the onset, was that if we were going to go up on medications, it would probably require her to be intubated. I don't recall what was said, but it was brought up that overall this wouldn't serve the greater good, that the benefit of undergoing the risk of anesthesia and intubation wasn't greater than the risk. And so whether that changed on Saturday with the dad, but then when the mom came, she agreed.
What does that have to do with my question about whether you could blame the parents for a disagreement among the team about intubating or not intubating?
Because it's not blame. We're not saying that the mom or dad were wrong in disagreeing. We're just laying out that we expressed to them that this was risky and that we weren't comfortable putting her at that risk.
You personally are not blaming Beata or Jack for this discussion, or to the extent that it was a disagreement about whether to raise the ketamine or to intubate. Is that fair enough to say?
Yeah.
Just a couple of concerned parents, basically?
Yes.
Did you at this point talk to Dr. Kirkpatrick or Dr. Hanna about why they had prescribed what they prescribed?
No, I personally didn't.
In fact, in this country, the United States, where there are two methodologies for treating a child, it is the parents who decide which physician they're going to follow, not for anyone else, particularly the doctors. Are you aware of that?
We're the ones who were directly taking care of her. So regardless of what prior physicians, future physicians would do, we were directly taking care of her Friday, Saturday, Sunday. So we take a team approach. We like to consider what she's received in the past. We like to always consider the parents' wishes. And most of all, we analyze the risks versus the benefits. If we perceive, using our medical training, using our team analysis, that the risks outweigh the benefits, then I don't care what a physician in the past has done. I don't care what a physician in the future has done. We're the one watching after Maya on that Saturday, on that Sunday. So we came up with a plan. We established a plan with Maya's mother and father Friday night because we knew that there would be issues given her history, given how complex this was, but that no one wanted to risk her dying over perceived pain control. So we established dosages. We said that we would not escalate beyond those dosages. So the meeting Sunday was about the mother's now insistence. And I believe at this time things started to become belligerent. Things started becoming talks of leaving the hospital.
It's in your patient's statement of rights. They can leave the hospital anytime they want.
I would not let any patient safely leave ICU, let alone a hospital, without safely turning down medications and watching for any side effects from those medications, such as respiratory depression, low blood pressure, nausea, headaches. So yes, any person can ask to leave a hospital right after a surgery. But what we'd try to do is educate patients and families on the fact that you need to, once you've been exposed to these high levels of medication, like propofol, which we all know historically is deadly, like ketamine, like Precedex, no, I wouldn't let somebody just walk out of a hospital once you've had those medications on.
This is the Patient's Rights and Responsibilities, Johns Hopkins Hospital. You see that?
Yes.
Are you familiar with it at all?
Yes.
Did you have any present fear for her life if she did not remain in the hospital?
Yes.
And number 20 says refuse care. She has the absolute right to refuse care. And so do her parents. You see that?
Correct.
And they refused your care. They wanted her transferred to Nemours, right?
So I spoke to an ICU physician at Nemours who stated that after reviewing our medical records along with previous medical records in conjunction with discussion with their pain team, a decision would be made about accepting the patient.
Okay.
So I actually followed the parents' wishes and made a referral.
Yeah, but your referral was based on a Munchausen by proxy psychiatric referral, not on a comprehensive.
Oh, no, absolutely not.
CRPS.
No, my referral was on the diagnosis of CRPS. Up until this point, and even after this point, because this was my last contact with the patient, I was operating under the diagnosis of CRPS.
And so one of your reasons here is the mother's reluctance to turn over medical records. Is that right?
Yes. Mom agreed to obtain all her records from Dr. Hanna and Dr. Kirkpatrick and stated that she would send them directly to Nemours.
Okay.
We asked if the records could be sent to ACH, and then we would send them as a complete package with our records, but she stated that she preferred to send it to them directly.
Okay. So she was willing to send out the medical records to Nemours. What's the problem there?
We undertook the care of Maya, and we were continued undertaking the care of Maya, so it was a reasonable request that we see the records.
But she didn't want you to take care of Maya anymore, and they told you they didn't want you to take care of Maya anymore. They wanted you to simply transfer them to Nemours, correct?
Which is exactly why I made the referral.
Okay.
And we were told that they would make a decision.
Well, so why not just leave it there? You have made the referral to Nemours. They don't want to deal with you anymore. And you don't want to deal with them anymore, apparently.
Well, that's not true.
But they don't want you taking care of her anymore. They want to get as far... Did you understand they wanted to get as far away from ACH as possible by this point? Did you understand that at all?
I understood that the family did not agree to our treatment plan, that they did not like the fact that we weren't willing to escalate the medications beyond our agreed treatment plan, and that they wanted to leave, yes.
Because they had the right to leave under your own patient statement of rights, correct?
Yes, absolutely.
Right. But they didn't get to leave, did they?
No, I was done taking care of the patient by Monday morning.
You say mother's reluctance to turn over medical records. I don't see anywhere here where you required, demanded, or put in front of her a medical authorization to do so.
Form. I didn't write the words, but part of her not agreeing would be her not signing the release of information.
And so now you stick in here the fact that the child is receiving highly mind-altering meds. What's the highly mind-altering med?
Combination of the propofol, ketamine, and Precedex.
That you guys were giving her?
Correct.
Okay. that could lead to withdrawal? Do you have any evidence anywhere in the record that this child experienced withdrawal symptoms from any of this, ever?
No, that's why I wrote could lead to withdrawal.
Well, ketamine has no physiological withdrawal effects. You are aware of that.
High doses for a prolonged period of time, I don't think you can show me evidence that it doesn't.
Where is any literature, I'll represent to you, the experts have looked at this long and hard, where is there any study that, other than pop science and junk science, like Psychology Today or something in the newspaper, where is there any study that shows that ketamine has a documented withdrawal?
One of the things that we're discovering with medicine recently, where we thought that ketamine didn't have long-term side effects, is that no, in fact, long-term infusions can lead to withdrawal. I don't understand your question.
Did you look at any studies or research before you made the assertion in here that mind-altering meds that could lead to withdrawal? Where was the psych consult in... where was the psych consult?
Mom has already refused psychiatry to speak with Maya multiple times.
Why didn't you just let these people go? If they wanted to go and your own patients' rights say they can go, why don't you just let them take their child and leave the hospital?
Because in order to let someone safely go when they've been on this type of medication, you don't want to just abruptly turn it off and then pull out the IV and let them walk out.
Why not?
Because you want to watch for side effects. You want to make sure that you, to the best of your ability, have accounted for anything that you could have done to them while they were receiving this medication. So if, for example, that this medication caused them to retain urine, okay, sometimes your bladder becomes atrophic, and so now you're holding on to urine, and so it's exacerbating your pain. That's because some of this medicine is it's still in your system. So now you have to possibly get a Foley. You need a urinary catheter placed so that you can relieve urine. Like I described before, the nauseous and the headache side effects of this, which could make you unstable to walk. Then you crack your head because you fall on the sidewalk. It's just not safe to get heavy dose anesthesia, stop it, and then walk out of a hospital.
If you were so concerned after this, when did you become concerned about them leaving the hospital?
Sunday evening.
How long did you feel you needed to observe Maya coming off the meds?
When you're on that type of medication, probably half a day.
So she could check out the next day.
If everything got sorted away and Nemours accepted, yeah.
What if they said, we don't want to go to Nemours anymore, we don't want to drive up to Orlando. Mm-hmm. They just wanted to leave.
Mm-hmm. Yeah, I mean, there might be differing opinions, but my personal opinion, half a day, yeah.
So why don't you stop the medicines on Sunday night? They didn't agree with your treatment, and they wanted to get their child out of there. And then you see how she's doing by noon the next day and let them go. Why not do that?
Because we were still treating her pain. They were obviously insistent that we escalate. I'm not going to completely stop everything, especially if you're telling me that you feel like she's still in pain. And the initial plan that we agreed upon on Friday night with the family is that we would go till Monday morning. So I was sticking with the plan. We'll go till Monday morning. You feel like things haven't improved. I'm going to make the referral to Nemours. We'll wait to hear what they have to say, and we'll take it from there.
We saw Jack Kowalski engage in any deception with you, did you? No. And you never really saw refusals by Beata, but you never saw Beata trying to intentionally deceive you, did you?
We were waiting on the referral from Nemours.
You'd been on duty all day?
Yes.
Okay, and you had a disagreement with them? You had a disagreement with the Kowalskis in that meeting about the type of treatment. right?
Yeah, about escalating care and the inability to provide records. That what?
There is a lack of correlation with certain treatments and the patient's perception of pain.
Yes.
Okay.
We were aware of that, yeah.
And, so tell me the symptomology between CRPS and Munchausen by proxy.
Well, I can tell you the symptomology of CRPS.
Okay, tell me that.
Well, one, it's going to be generalized. It's going to be regional. But you can have a variant of generalized.
Okay.
It's going to be generalized, regional, or variant of generalized.
We're already stating that even though the fact that most of the times it's regional, she's presenting as this very generalized pain. It's not in one place. You're also going to have autonomic dysfunctions. You're going to have some type of either sweating or swelling of the extremity, temperature differences.
Did you do a thermography?
I don't believe that there were. Since her pain was generalized, there was not one place that we could put the temperature probe.
Prior physicians had measured the left arm from the right arm, the left leg from the right.
Well, in this acute presentation,
the right leg, right foot from the left foot. Did you do any measurements that way?
No, her pain was generalized, so no, we did not.
Okay. What else?
And then just the fact that the pain is going to be out of proportion to your physical exam findings.
Right. Allodynia?
Yes.
You noted that. But you had that.
Did I note that?
Yeah. You just said it like 3 times.
Yeah, generalized pain, yeah.
But also the pain was out of line with what you would expect.
Yeah.
Okay. Which is known as allodynia, is it not?
Yes.
Okay. And that's a chief symptom, one of the big 4 symptoms, is it not?
Yes.
Okay. And so she had pronounced dystonia in the feet, did she not?
She had an inability to stand up. Yes.
Okay. But her toes.
Dystonia implies tone. And I couldn't examine her, right? She wouldn't let me touch her because she was in so much pain. So I can't comment on dystonia. Dystonia is a physical exam finding. The inability to walk, pain to walk, is a symptom. She's reporting a symptom versus an actual physical exam finding.
Well, you could look at her feet. She came in a wheelchair, right?
By the time she was in the ICU, she was already on an ICU bed.
Okay. Did you ever look at her feet to notice there were photographs of her feet like, and I don't need to make this an exhibit, it's already an exhibit to a bunch, like this, the feet turned in, like this in the hospital.
That may or may not have been the case when she was in the ICU.
Okay. But you didn't specifically look for this?
I wasn't the one that did the history and physical note.
Okay.
I mean, I don't know if Dr. Tepa's note mentions it.
That's a classic CRPS symptom, is it not? Dystonia?
I'm not an expert enough to know if it's a classic symptom.
Can you take a look at number 6, exhibit 6 there? Particularly page 6 of 8. I'm just asking him about one specific additional part of it, and that's at page 6 of 8 under skin. Mm-hmm. Have you ever seen complex regional pain syndrome lesions?
No.
Did you have access to this page before, or this report? And what is this report? This is the
anesthesiologist.
Anesthesiologist report. On the skin it says 4 discrete round raised papules present on lower back. Do you see that?
Yes.
Are you familiar with complex regional pain syndrome lesions? What they look like?
No.
Was there ever any discussion, given the identification of these, to compare them to the literature to confirm these were an objective finding as to complex regional pain syndrome?
No.
Dr. Malik and the other doctors don't feel the child meets the criteria for RSD. Do you remember saying anything about that?
I remember saying that some of the findings were inconsistent.
Would you classify the relationship by the end of the evening Sunday as hostile between you and Beata Kowalski?
No more hostile than I've experienced with other families that may disagree.
Okay. Well, if you were going to describe it, how would you describe your relationship with...
She didn't like me.
Maya, Beata never said, put Maya in a coma. You couldn't put her in a coma in that hospital, right? You weren't set up to do a...
No, we do surgeries every day. We can put someone into a coma. We place people into a coma, and I believe that's those were her exact words when she came to the emergency room. When I received the phone call from the ER, I recall, said that she wants to put Maya into a coma.
Okay, for what reason?
To control the pain.
Okay, coma meaning under general anesthetic.
Yeah.
It's not really a coma. It's
semantics. General anesthesia, coma, they're the same thing.
Did you ever tell anyone at the hospital, Maya's not in any pain?
No.
But I want to make sure it's not your testimony here today to suggest that if in fact there was a question and it was phrased in a way that Dr. Smith was part of a hospital team that you believe or represented Dr. Smith was a treater here at the hospital for Maya.
No, Dr. Smith was one of the people that we contact to start the process of the investigation, but and that's who I got trained to contact. But she was independent of Old Children's. I knew that she worked for the county or whatever. She covered multiple hospitals.
Right. So not to put words in your mouth, but if I'm understanding you understood her to be and understand her to be a consultant that can be utilized by folks at the hospital if necessary regarding pediatric potential child abuse or neglect.
Yeah.
Maya was not only on ketamine during this 3-day period that you were involved in her care, she was also on 2 other pain medicines, correct?
Correct.
And what were they again?
Precedex and propofol.
What is Precedex?
That's the trade name. The generic name is dexmedetomidine. It can be used as a continuous infusion like ketamine and propofol, basically for sedation and analgesia. So it's an anesthetic.
Are there any, strike that, what are the potential ramifications of the abrupt cessation of Precedex in a critical care setting?
Everyone responds differently to anesthesia, but some of the potential side effects include things like urinary retention, nausea, vomiting, headaches, breathing issues, blood pressure issues.
Did you have any concerns about the cessation, the abrupt cessation without a tapering schedule of Precedex as it pertains to Maya Kowalski's care and treatment?
Yes.
Who were some of the other providers that would have been giving you updates or expressing issues related to Maya?
Her nurses, nurse practitioners, physician assistants, social workers, pharmacists, nutritionists.
Do you have any specific recollection of what any of the nurses told you and to pick you on any of the days that you were involved?
I remember that they were talking about the inconsistency with how she reported her pain when the family was in the room versus when they would ask her outside of the room.
All right, that completes the testimony.
Playing of the
It does,
deposition.
Your Honor.
And at this time, is that all for today for the jury?
We would like to publish the last 3 remaining emails from the coma series, if we could, before we conclude today.
Let's go ahead and do that real quick.
Okay, so the defense would publish Exhibit 3147. And this is email Beata Kowalski to Beata Kowalski, 11/22/15.
This is a lot to read to you guys. but this is written first person as if it were Maya writing the letter. This is Beata emailing to herself that this information is eventually going to end up in the blog that we hear about, Beata's blog, talking about how the treatment's going, the increased medication, just all sorts, everything that happened during this. It's documented in detail in first person. The jury's been on previous emails like this, because 3 more have been introduced earlier this morning without testimony, and the judge is okay with that. He ruled on this already. In previous emails, the jury's basically said, "Wait, we're not done yet," and they're reading these in detail. They're going into every bit of this. The prior witness there, we finally got through the deposition. Third time was the charm, and it's funny because it started out very much in favor of, I would say, favorable responses for the plaintiff's case. It was believable, saying, "Hey, we should treat her for CPS. We shouldn't. She does have pain. We should proceed that way." This doctor seemed to be more of a dissenting voice among the treatment plan providers, and very, very reasonable in his responses. And I'm saying that not as far as his medical decisions. That's well outside of my realm of expertise. But in his response to the different sides and his openness to share exactly why a decision was made. The part that I saw in chat where everyone's like, "Whoa," just a little bit, was when he started talking about AMA, leaving against medical advice, and why he would not allow someone to leave against medical advice, because we'd want to monitor it, we'd want to keep doing that. Well, that would be what the medical advice is. The whole procedure for leaving against medical advice is when the family does not want that. And here there was a conflict there where he's like, "No, I wouldn't allow someone to leave AMA because we want to continue the treatment, or we would at least want to ramp things down until a point where we're comfortable, and then you can leave at that point." So heard a couple names in there. We heard that the social worker was involved and does influence the care. That you slid in there.
Anyone
if you
need any more
listen
time?
carefully.
Okay, the next one, the series judges, defense exhibit 3150.
Colleen McBee says, "I agree with RA about that. The depot. The doctor seemed honest. Apparently, he's used to parents being angry at him." Yeah, and he's cool with it. He says, "How is the family?" He says, "Well, they're not any angrier than any other family would be when I won't let them leave AMA." So at least he's consistent across the board. Let me fix my screen here. Right, day 6 was a fairly good day. This one starts out, "God and Dr. Cantu are trying to give me a little break, save energy, eat, etc. Before day 7, ketamine infusion was stopped at 10 a.m. Lots of this. This is like doctor notes. This is it's both a story as well as a medical chart mixed into one. And because I'm still a Supergirl, I still require high doses of sedatives and additional Beluses. That's like a one-time shot, right? It's Beluses. To keep me down. I wonder what will be my favorite drink when I wake up from coma." So this is mixed, both a documentary, a child's voice, and
Anyone else need more time?
Sort of like creative writing all into one.
Just a little bit more time.
I've got a lot of calls. I've spoken to people who have called me on the burner phone. I've got a lot of texts from people who have been in a situation where a family member went through this, and they say, "This is not strange. This is not abnormal." In this situation, a lot of times it's a way to stay sane and deal with everything that's going on, and just blog it and have a record.
Anyone
so you
else
know
need
what's
more
happening,
time?
but it's in this comfortable.
Your next one, please, Mr.
format.
Shapiro.
Yes, sir. 3148.
Bolus. Thank you. I knew that was. I was trying to say blouses. That's not the right word either. A bolus.
And this is November 25th, 2015, ketamine coma day 7.
Oh, just heard from Brian Enton. Brian Enton is with News Nation on Twitter. He just said, Koberger judge says he will not ban cameras in the courtroom. Says instead he will take more control of the cameras. So how that will actually look for the BK case will determine whether or not I'm able to go to Idaho and bring you the live feed directly. An MD can write an order that a patient cannot leave AMA, typically deemed not competent to make medical decisions per psych. Is that when the patient's making the decision, though, Jennifer? Would that be when the patient themselves say, I don't want to receive treatment anymore, I want to leave, and the doctor can say, you're not in a state where you can make that decision? Or would that would apply to a parent as well, saying we don't want to pursue this course of treatment with our child? Because I can see if you get some, you dope somebody up on meds to deal with pain or something, and in their loopy state, they're like, hey, I feel great, I'd like to leave the hospital, why am I here? Of course, that would make sense. Bianca says, right, but psych didn't make that order. That's correct. It didn't happen. Listen to Learn says, you're in if the cameras are in. It's not that easy, unfortunately. There's still a lot of motions I'll have to file personally with the court just to make sure I get the access that we're looking for. And there's a lot of equipment involved as well. One of my cables that I want, if we're going to cover this, is $850. I know that's ridiculous. It's actually it's called a snake. It's a cable snake. But it allows me to connect and get potentially all the camera feeds simultaneously instead of just a single camera feed, which is something I've really been pushing for. Ariel says, hospital can't stop a parent from leaving with child unless specified circumstances, like the child's life is risk of imminent danger, parent refuses life-saving intervention. I think we sort of got that testimony that he did say it was life-threatening.
Okay, more time.
Or he came very close to that threshold in what he said in his testimony here. My Dog Clover, since this is not Maya, but her mother, how is this admissible as coming from the child? The judge has ruled that these are relevant. It goes to some of the allegations and the claims that the plaintiff has made, and it goes to the defense that the defense is putting up, the theory of defense that they're putting up. It is also, I think he ruled that this could be considered statement by a party opponent against interest. So basically, it's like the other side admitted this. Defense is saying, hey, they said this is happening. We've said that, and here we've got a document that shows it. That's how it gets around the hearsay rule. So there's a lot that went into the decision to allow these. We also had a decision because the plaintiff got the opportunity to insert documents
Looks
without
like okay.
testimony from a witness.
That
the defense
will
did as well.
likely end the defense presentation for today, Your Honor.
Okay, members of the jury, I think this is a good time to say goodbye today. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. 9 a.m. start time for the jury tomorrow. Have a wonderful evening.
Okay, 9 a.m. start time for the jury. Lynn says, but the hospital did not take legal steps to keep Maya those days. They just lied, conspired, and covered up. Jennifer says, let me clarify. Not saying that would be appropriate in this case. Thank you, Jennifer. That makes sense. Obviously, we don't know all the details of this case, and I'm not the person to argue this, but thank you for bringing that up. There are situations where the doctors can say, no, you can't leave AMA.
Thank you. The jury is out of our presence. Everyone, please be seated. Let's finish up on the issue that we were discussing before we took the deposition.
Regarding the prescriptions?
Prescriptions, yeah.
The prescriptions were filled out.
They were filled?
Oh, they were filled.
And are those records and evidence the pharmacy records?
They're looking, but it sounds like perhaps they were omitted unless they were attached to something. Are the emails part of it? The emails are part of them, which is this. I guess there's email correspondence confirming it. I don't know if the actual record is, and perhaps we could provide to plaintiff's counsel, see if they have an objection to us adding it at this point. We'll send it to you.
I wonder if this evidence they were filled.
It was I believe, an attachment to Mr. Schott's deposition.
It was actually to Jocelyn Krager, who's another form.
DSM, thank you.
It was an attachment to her deposition.
It's been disclosed to plaintiff's counsel before trial, but I guess inadvertently left off our list.
Mr. Schott has also testified it was filled. Mr. Schott also has email correspondence indicating it was filled. And the internal quorum pharmacy records indicate that the lot was filled on 2 different occasions. The lot is also known as hybrid firm.
Give it a shot, Whitney.
Yes.
Give it a shot.
There's no exhibit number on here. They've handed me a patient medication profile from Quorum. It is Bates stamped. It says start date, stop date. It looks like it was, if filled, stopped by November 13th or November 17th. There's 2 indications here. So it was about a 2-week period. If this record is accurate, we would maintain that Dr. Kirkpatrick already testified that he was trying to get her some acute medication to get down to Mexico, and it's not relevant to anything that's going on here.
Might be coming in.
We would just call the witness to have and verify that this is the medication list from your company. These are the medications you filled. I can tell Your Honor how, I know what Your Honor's concerns were at the bench. I'm happy to disclose how I would argue this to the jury if you'd like to hear.
Yes, please.
Yeah, sure. So, for example, in a closing argument, I would lay out to the jury, here are the medication profiles that Maya required for her pain through this period of time, even after the first doses of ketamine given by Dr. Kirkpatrick, which you've heard were 1 milligram per kilogram per hour, then 1.5, then 2. I can't remember if we went up to 3. Those failed. Yeah, 3 milligrams per kilogram per hour. Those failed. The patient still required these, what we would consider to be significant good doses of hydromorphone, opiates, to get her through and crutch her through to Mexico. Then she required the ketamine coma in Mexico. As we've seen from the blogs, there were what we would consider complications and significant ones. And then she still required significant doses of ketamine from Dr. Hanna that eventually increased into September and early October of 2016. And then All Children's, once she got into the ICU, as you heard from Dr. Malik, started to wean her down off those medications. Ladies and gentlemen of the jury, what we would submit to you is after she left All Children's Hospital and continued with the practice of just physical therapy, occupational therapy, and perseverance in time, without these medications, she was able to make a substantial recovery. So we would be able to contrast with the jury that the medication she was on during this period of when she was in the wheelchair was hampering her rehabilitation. Contrast that to All Children's taking her off these medications and showing how well she's done. And we believe that's very important to the defense, especially when they have a vocational rehabilitation planner who said that her course of treatment was accelerating her, to an A+ course. And because of All Children's aggravation of an injury, now she is either partially or fully disabled.
Anything further, Mr. Whitney?
I think the only thing that I need to respond to is to point out again that the argument that was just relayed there requires us to get into the reason that ketamine was no longer provided to Maya Kowalski upon discharge. They clearly did argue that. Well, I'll leave that there.
Well, on that issue, I think I've said on multiple occasions, your clients can testify as to what they understood or what they felt or what they were fearful of if they were to get ketamine again. I think I've said that, 4 times now? So I feel like that issue, there's a path for you to address. Now, going back to the actual pharmacy or the script, redacting out that information about terminal illness, I'll go ahead and admit it.
Okay, thank you, Your Honor.
I don't know what number that is, so can you? And we might need to do an A because you're going to redact it. So perhaps in the morning, let's do it so the clerk will have the actual redacted version.
Yes, Your Honor.
Do we have, Mr. Sorensen, a time?
I have it, Judge.
Ms. Crowell.
For the Malik death, or Malik death, defense 11 minutes 10 seconds, plaintiff 18 minutes 20 seconds, and then Green, which is the combined both, 20 minutes 35 seconds.
So we split the combined, and then I'm not sure why they broke it out that way.
Let me do the...
Make the judge do the math, apparently. Shot clock. Pay attention, guys. Get your pencils out. Apparently they have an email that discusses it was picked up or filled of some way. I didn't see the evidence. The judge, I think, did and ruled it admissible. She's keeping track because their side is the one that did the cut down of the video. They did the
plaintiffs
editing.
consumed 1 hour 20 minutes today for a cumulative total of 55 hours 20 minutes. The defense used 2 hours 5 minutes today for a cumulative total of 35 hours.
35. Counted the wrong way.
10 minutes.
10. Okay, so 55:20 and 35:10.
I know it's Friday, but who's coming tomorrow?
I think I announced it earlier, Your Honor. Dr. Jennifer McCain is a psychologist from Tampa General. Mr. Schott, the pharmacist, and Mr. Bankert, he's our billing and coding employee. He's not an expert, but he's going to explain the billing issues. We originally were going to have him last week, and then there was a discussion about directed verdicts. Then we anticipate being able to play the depositions of Dr. Hanna and to play the deposition of the guardian ad litem. Is that right?
Yeah.
That should be a pretty full day.
No, guardian ad litem, yes, we didn't have any objections. The judge has already ruled on the other ones, so it just needs to be edited.
So 3 live witnesses, 2 depositions as we can, and
it's a busy day.
We might need to have a short discussion at the end of the day about the scope of, and I'll wait for Mr. Anderson to be here, but we have our child abuse pediatrics expert that mirrors Dr. Newberger, so just so I can prepare him over the weekend about permissible scopes of testimony.
And my homework tonight is I saw that there was some some objections for a deposition.
Dr. Vose.
Dr. Vose?
Dr. Vose, the first deposition.
Now, do we need that for purposes of tomorrow?
No.
Okay, so I don't need to.
Taking it off, Judge.
Well, it's not that.
I know. But
Thank you, Carrie
No,
Bott.
I think between
Thank you so much.
those witnesses, Hannah and the guardian ad litem death, I think that will fill tomorrow, Judge.
Anything from the plaintiff side for tomorrow that we need to talk about?
We need to discuss.
Fabre.
We'd like this deposition now to get to the bottom of Edie's performance review.
When do you want to do that?
And we'd like to do that this weekend. And keep witness Anderson on recall. And then, just really again, we're waiting for a Fabre decision so that Mr. Elliott can work on the verdict form of instruction.
Are we at a decision point yet on Fabre?
I think Mr. Altenberg has that answer for Mr. Altenberg. We'll be discussing that with Mr. Elliott.
First, we can advise the court first thing in the morning. I know Your Honor's thinking, we're going to advise the court first thing in the morning.
They were supposed to
I
do
need
it
to get
today
final proof, Judge.
at lunch.
Okay. That's fine. It's I appreciate that everyone has to check with whomever they need to check with.
Judge, if you do have one exhibit we could take care of.
Sure.
Well, it's one that we had previously discussed. It's 3217. Yeah, that'd be fine. The one where they said we want it all before in if you're going to put the part in. So there's only one. So is that highlighted, Mr. Whitney?
Yeah.
So Mr. Whitney has highlighted what he wants redacted. I'm fine with all of it except for on 0572. He wants to at the bottom there, he wants to remove due to the case being brought up and mention of the judge and his decisions. I just think it needs to be in there because it doesn't talk about what the substance is. Just that's why I had to redirect you. That's the only highlighting that I don't agree with. The rest we're happy to redact.
No, we need to redact that.
Okay, so we would stop at, on the phone, I had to redirect.
And it's been a full day since I've looked at it. Is there anything in here by implication that's going to get us in trouble on the gravity of Chapter 39?
No, I think that's why he's redacted the other things.
Those are my redactions.
So we're happy to do that. We'll redact it and have it ready for the morning.
Thank you. And speaking of the gravity of Chapter 39, I wanted to say how much I appreciated both sides trying to live within the court's order with respect to Dr. Sally Smith. And, I think she said trying to thread the needle. And so I appreciate both sides working. And I know you disagreed with some of the court's rulings on it, but I do appreciate y'all trying to stick to what we had talked about. Thank you.
Thank you, Your Honor.
Anything else we need to discuss today?
I don't think so.
All right.
Is 8:30, or how much time do we need tomorrow morning? Do we need a full 30 minutes, or
I don't think so.
would you like to come at 8:45?
No, I'm just going through the witnesses real quick in my mind. I think 8:45 is fine. So yes, we should be fine at 8:45. Would you consider this ready?
Ms. Lawrence had like a big smile on her face.
8:45 is fine from the defense, Your Honor.
Then 8:45 tomorrow morning is when we will reassemble. And look, it's not even 5 o'clock yet.
And we got Dr. Mallard played. I'm considering that a success, Judge.
Okay. We'll be in recess. Have a good night, everyone.
Thank you.
There we go. All right. So as they are filing out of the courtroom, let me just say thank you for those that are contributing to the cable fund. This is for the BK trial. We've got more than a year, so no rush. We'll get this. The specific cable. I'm planning on getting this already. It's a 5-channel BNC SDI 6G cable for you nerds out there. That's 75 feet long. So it allows me to connect to whatever device or a splitter that the court feed is available to at the media pool location, and run it to my equipment, so I'm not setting up all my equipment right next to the splitter. But that's all. We've got plenty of time. We'll get it. No rush at all. Goodman Law says, I may have one. It's 5 cables in one, so it can run it can run 5 4K video signals down it. But it's only going to be 1080p because that's all they do in court. Anyway, is Jules going to call in? She might. I think she's left the courtroom, so we're just waiting for to see if she has anything to share with us this afternoon. I'm excited to get a little sleep tonight. 6G. I would get the 12G, Peter. I would get the 12G cable. Realize this is not like the same as a phone 5G, 6G. It's separate. The 12G is really high end cable. Just amazing stuff, but it like triples in price. And since we're only going to be pushing a 1080p signal at best, I don't need that. Did Jules call in earlier? Yes, we have talked to her once today. We talked to her on lunch. She might call in today. I'm not sure. We'll keep the phone light open in case she does. Goodman Law Firm, open invitation to all. I think it was. If you guys read that, you guys read that the same way I did. We're all invited. She's got a giant guest room, theater for the kiddos. Just kidding. Can crash at my pad with the missus while you're out here in the potato country. We might have to talk. Nicole, we might have to talk. 80s Music Man says, hey, RA, it's official. Been a year now since I came through chat doors, even though this says 7 months. I love the hoodie. Thank you. I'm glad you got the hoodie. It said you weren't going to get it for several weeks. We had a moment where we were desperately trying to get 80s Music Man back in green, and it struggled and struggled. And I said, look, let me just send you a hoodie. And it arrived. He sent me pictures. I hope he loves it. It arrived even in time for Halloween. It's one of the this is my prison escape hoodies. It's the gray zip up version, I think, that we sent him. So glad you got that. Thank you so much. And appreciate 80s Music Man has helped out this channel a ton. Even in just providing levity at times where we've sat through some really difficult court sessions. And it's just been fantastic to have him here. So I appreciate that. Okay. Anything else? Was Rob on from off from Lawn and Lumber yesterday? He had court today, but I think let me just check. Let me see if we can redirect. I think he has a wrap up tonight. One of his mods reached out to me to let me know. Let me double check. We'll do a redirect to his channel because I think he wants to talk about this. Just one second. Jules is on the phone. Hold on a second. We've got Jules on.
Jules.
Jules, good evening. How are you doing?
Okay, I'm tired. I'm
should be.
tired. I'm mentally exhausted. Yes, it was a very long day, and it was a very emotional day. And a friend of mine pointed out that when I called you earlier that I left out one of the most important things, and that's why I'm calling you back.
Okay, let's start with that.
After Sally Smith was done testifying and leaving the courtroom, okay, I just forget to tell you this. She was escorted out by 2 deputies, but not through the front doors. They took her out to the back, walked her around the building, and then we could see her out the window, and they literally walked her to her car. She got in her car, and once she pulled away, the deputies came back inside.
Wow. That's for safety. That's normal. Goodman Law says that's normal for safety. Were there protesters still out there? Do you know?
Not when she left. No, there was not. It was very, very quiet at that point because everything that happened when she arrived.
Yeah. Well, Jules, I'm glad you called in. I actually had a question that I wanted to ask you personally.
Okay.
When the judge was reading the jury instructions, what was the jury doing then? Because we had some argument in court that the plaintiff, I think it was Mr. Whitney, argued he didn't want it read and shown on the screen. And defense is like, yeah, they're visual learners. We want them to see it. What was the jury doing? Were they frantically scribbling notes?
Here's the weird thing. Judge Carroll was reading it. They weren't watching their monitors, every single one of them. And don't ask me why they were doing this, because the judge made it really clear that at the end of the trial, all of this was going to go back with them. Every single one of them was writing down what Judge Carroll was saying. They were not reading it.
Wow. Interesting. So they're forming questions and making notes, mental notes, as they're hearing it, even knowing that they're going to have a written copy of everything verbatim that they just heard.
Yes, that's exactly what they were doing.
This just goes to emphasize the point that these rules, these jury instruction rules that we've heard argued over several weeks, are critical to the case, because this is the framework that the jury uses to decide this, to weigh all the evidence. A lot of the battle of the court is fought in the jury instructions, and so it just shows the impact of that. Wow.
Any other questions?
Let's see. I haven't been watching chat. Is there anything? I don't see anything with your hands up. Everyone's saying thank you and hearts for Jules.
You're very welcome, guys.
I think
You're very welcome.
Rob is on tonight. Do you have plans to be on there as well? He's going to be on 8:30 p.m. Eastern.
I'll be in the chat for that. And Also, I was told this afternoon, actually after I got off the phone with you and ran back in, I have a Fifth Amendment right to speak on what I see in the courtroom. I could speak to whatever, whenever, and that's my Fifth Amendment right, because it was brought to my, some people were saying I shouldn't be talking, I shouldn't be doing this, shouldn't be doing that. And I literally went to two attorneys and they were like, nope, you're allowed to say or do whatever you want.
100%, unless there's a court order in place that prevents something. You really are 100% in the right, and you do an amazing job at it, Jules. I really appreciate you. Thank you so much.
No problem. What did you think about the nurse?
Wow.
Yeah, I was sitting there, wow, and I can tell you during direct, jurors were taking notes. When Greg got up to cross her, juror 12, I can't remember which question it was, but Greg tripped her up a couple of times.
Yeah.
And don't think it didn't get past definitely two of the jurors. Okay, it was juror 6 and juror 12, so much so that juror 12 was sitting there smirking and nodding his head down like, gotcha.
Yeah, it was. She was an inexperienced witness, and I think she did get sort of led down a trap and didn't notice that what she had just said or agreed to. I don't think it's a huge loss on the defense. Anyone who sat through trial knew that was sort of a trap question, a catch-22, a gotcha, and they tried to bring her back a little bit on the redirect, and I think they made it clear that that's the case. We've got a couple questions for you. Let's see. One was from Joe Gottman. Says, Jules, did you think the jury instructions were more for the defense? And thank you so much.
Yes, that's my opinion, but yes, I do believe that the defense thinks that these jury instructions are going to sway the jury their way.
Here's another one from Madeline Warner. Says, Jules, how's the jury today? How were they on the last depot? This is the depot we've seen part of twice before, and then we got to see all of it finally today.
Okay, generally speaking, they were very stoic right from early this morning. They were not their normal selves the way, like yesterday you said, do you think they have burnout? And I was like, absolutely not. Mm-hmm. Today, they were, all of them were just very different. They took notes for Sally Smith. Obviously, they had questions for her. With the nurse, they got a little more back to the way they have been previously. And with the depot, I don't know what to say about that. They were taking notes. They were taking a lot of notes, and all of them were taking notes. And the downside about the depot is you can't read the jury because they can't ask questions on a depot.
Yep.
So
that's the frustrating part for us. A couple people, Jessica O and Irish and Scottish, are saying, ask how the jury reacted to Beata's emails. We had 6 pages of emails that were admitted, 3 at one time, 3 at another today, just to be presented on the screen for the jury to review. What was their reaction to that?
5 and 6 looked at each other. 11 and 12 looked at each other. They all were writing stuff down, even though they know this is the part that confuses me with this jury. They're told these things are going to go back with you, yet they're taking notes on what they're seeing. So I don't know, but they all were taking notes, and like I said, 5 and 6. Kind of just looked at each other, as well as 11 and 12. And I could tell you this, 11 and 12 throughout this trial, you can just tell their personalities meld. They have formed a bond with each other, as well as 5 and 6. You can tell those two definitely formed a bond with each other. And then juror 8, 9, and 1. Those 3 kind of are together, as far as you can, you can tell when they interact with each other. So they kind of are clicky.
About the interaction, I realize this is like it's one of the few tells we have, but there are a few times that the jury gets asked a question, we get to hear them all sort of respond or sort of vote, right? And it's on something small, like, do you want to take a break? Do you want the lights down? Are they all, is there like a ringleader that makes and says, is there like a definite like a potential for foreman who's like, hey, let's do this, and everyone agrees? Or is everyone just, they just go along to get along?
Yeah, they all agree. It's like, I know, I've been looking for that, Scott. I was like saying to myself, okay, which one of these people are going to be the foreman? I don't know. I don't know, because they're all in agreement. 3 and 12 take stretch breaks.
They're the ones that just stand up during court,
depositions. Right? Yes, they're allowed to stand up. They do it a lot during sidebars and during depositions. I do know that they don't like the lights turned down. They and this was a group thing. They're like, Judge, it makes us tired.
Yeah.
So no lights. I mean, we don't want lights turned down for the depositions. But yeah, I don't know. I have no idea who's going to be the foreperson. No clue.
There was one more thing I want to talk to you about, and thank you very much for your time, Jules. This is incredible.
No problem.
There was one point where the attorneys were up at the judge's bench, and they were talking about the jury questions, and I forget which witness this was on. But Mr. Shapiro raised some concerns about a juror who specifically asked a question. He's like, this would indicate that this question is like ripped from Taking Care of Maya, the movie. And he had some concerns about that. What was your take on that moment?
My take is that Mr. Shapiro is a crybaby. I mean, I'm sorry. I mean, it is what it is. Yes. Could it be? Could he be right? He could be. But because of all the testimony they have heard, I don't believe it had anything to do. I don't believe it had anything to do with the Netflix series. And again, I have faith in when they're told not to do something. I don't believe that they would go against that. And let's face it, all this time, these people, have sacrificed themselves for this trial, whether it's an alternate or not, because they don't know. They don't know among them which ones are going to actually deliberate. So why would they risk that and then get thrown off? You know what I mean?
Yep. The judge and the attorneys know which ones are the alternates. And,
they do.
And you have some insights as well. But the general public, we don't know which ones are going to be deliberating with the 6 and which are not. So, Jules, once again,
but you'll know the day it goes to goes to deliberations. You will know that. Also, there was something else. Oh, this is what I got during the jury selection. Okay, and I'm allowed to speak about this.
Yeah.
Because I made sure it was cleared. Okay, because I wasn't there for jury selection. But I spoke with an individual that took part in that, okay? And it was the defense that didn't want young mothers. They didn't want anybody with young children. What was the other things that they were... I can't remember now. It was they didn't want anybody with young children. They didn't want anybody that that had severe health issues in their family or someone that they knew, and they didn't want young mothers, which I thought was kind of odd.
So, did they use all their preemptive strikes in jury selection? Do we know?
As far as I am aware, yes, they did. And what I was told today is that primarily the defense got what they wanted within this jury. So they can complain and cry all they want. You set the parameters and you got what you wanted. And I told you that these jurors are, and I am bad with ages, but to me, they appear to be late 40s into their late 60s, with the exception of one who appears to be maybe mid to late 30s. So,
do you have an indication of which one is the gamer, the one who had the noob question the other day?
Yes.
Is it a younger male? Is that?
Yes.
Okay, that's when I heard noob. That's the only terms I've heard that associated with is younger males who play, first-person shooters online, or spend a lot of time with an Xbox or something.
That's the first one that crossed my mind. That's who it was, only because it was just the way it was worded, and when they came back. Okay, and the judge started reading the questions. As he changed newbie to new.
Yeah.
I saw the one juror kind of
do a little facial smirk or
laugh
something.
a little bit. Yeah, a little laugh.
He's like, I had
and
the
that's
perfect
why
word
I
for
think
that, and
was
you
the
cut
one.
it out.
That's
wonderful.
And that's that's where we stand. It is also to my understanding that on Monday, the guy I told you about, John Stewart, he knows that Kathy Beatty is going to be in on Monday. And when I left court, he messaged me and he said, Julie, I'll see you on Monday. And I answered him and I said, please don't, because I really am afraid he's going to go to jail.
He does have a right within his area. It's also protected speech, but sometimes you're right doesn't mean it's not wrong.
Yes, and there is an area. There is an area that is set up for assembly where you can go and assemble, and it's all has the barricades around it. But see, the problem is that that's not what he did.
Yeah,
he as soon as he saw her exit her car, he went straight to her, and And then after he got the reprimand and all of that, that's when he ended up in the assembly area. And he did send me the video. He said, he sent me the video this afternoon. Here's the altercation with the deputies. Please put it on your TikTok. So I messaged him. I was like, did you record it with Sally Smith? And he goes, no, because I was so angry that I totally forgot to do that. And I was like, okay, this will have to do. So, but I have he sent me the video of the altercation between him and the deputy.
Let me do that. We can have one of the mods put Jules' TikTok account up on the screen. Jules, you've been fantastic. You do have a TikTok you put some information up to, and we'd like to send some people that way if they want to see that information. That would be a great thing to do. I'll send you a text message as well. I need to talk to you off the air about something. But Jules, once again, fantastic reporting. I'd hire you in a heartbeat to be a reporter any day. So, thank you. Thank you very much.
Well, real quick question: Are you going to cover Petito versus Laundrie in May?
That's another civil suit, right?
It is. It is.
Is it with the same judge?
It is. In the same courtroom, same judge. I'm just throwing it out there. I'm going to be there every day. So if you decide to cover it, just shoot me. You have my number. Shoot me a text message and let me know. That's all.
We're looking at moving to the next phase of covering trials where we have hardware on the scene to get video feeds that are that we have more control over than some of the other ways we do this.
Okay.
So I've got work on my end to get all that built together and tested and operational. But we'll let you know. I don't think we have anything else even tentatively scheduled for that part of the year. I mean, Sarah Boone's going to be done at the end of the year. We've got.
Yep.
I don't know when Corey Richens is going to happen. That's going to be going for a while.
I don't know that one either. I was thinking about going to Sarah Boone. It is a 3-hour drive for me. So when we get closer, I will make up my mind on that.
The lawyer you know is going to be at Sarah Boone's at least partially, even in court. Peter Tragos is going to be there, and so I look forward to that. He's been covering that pretty thoroughly. But I'm having a little trouble getting the media access I want from the Sarah Boone trial because of some of the weird rules that require you to have independent editors on your website for at least 6 months covering the story. There's bizarre rules behind this and a lot of paperwork that we're trying to filter our way through. But anyway, we'll try on that one. Jules, thank you very much. Drive safely. We'll talk to you tomorrow. Thank you so much.
I will, and tell everybody have a good evening, and I'll talk to you tomorrow.
Did. Thank you very much. We'll see you.
All right. Bye-bye.
Jules is fantastic. Thank you so much. Appreciate it. Let's see. Michelle says, can you talk about the new Sarah Boone letter? I think we can. Obviously we can, but we're not going to do it today. I think we're going to cover this when we have a down day. We have a down day coming up in this trial, I think. Well, we've got a vacation day, right? I think we have a vacation day coming up a week from Friday, which might be during deliberation. I don't know. It might be right after this trial ends and we have a verdict. But we'll definitely cover that. All right. Any other questions I can answer for you? Let's see. FBI seem to be closing on the main manhunt around his home address. They've been doing a lot of work up there. I've seen that the Coast Guard's involved searching the river because there's a concern that he made a getaway on a boat. We know that there was a note that was recovered from his house that's obviously getting a lot of scrutiny. I don't know. I don't think we're going to cover the manhunt tonight just because this particular hunt, they've sort of locked down the communications such that there's not a lot of information available to us. So me going live, although I love covering this, I love following it. It would be me just saying the same thing over and over and not really providing the information that would be helpful as far as what's going on right now, just because it's very difficult to get that information. So I don't think we'll go live for that. As far as the time left, Sarah Cambridge, great question. I did the math by my math. The plaintiffs only have 3 hours and 40 minutes remaining, and the defense has 23 hours and 50 minutes left. The plaintiffs used, once again, more than an hour today with an hour and 20 minutes. Defense only used 2 hours and 5 minutes, and that's jury time, the time in front of the jury. Are you going to go to the manhunt for card? Debbie, not unless we find if there's an information source out there, whether it be a police radio channel or we see a lot of activity in the air, things like that, we might do something, but we're not going to do a live stream as of right now about that. I kept missing it. What was the juror question that prompted the Netflix response at sidebar? Ashley, that was, I'm trying to remember. Was that to Sally Smith? I think it was to Sally Smith. One of the last questions to Sally Smith. I'd have to go back and rewind it. When I do the repeating what I hear in Zoom, my retention is much lower than normal. But I have to go check. I apologize. I don't have it off the top of my head. Mrs. R.A. says, hey, hello, wife. Says, Recovery Addict owes me a date tonight. Just saying. We're going to go to the store and we're going to buy some candy. That's what our date night's going to consist of. All right, that's my cue, ladies and gentlemen. That's my cue that we need to wrap this up. So thank you all very much. This has been a lot of fun following this trial today with the ups and downs of this case, which is one of the most complex we have covered. It is incredibly complex because of that. I am so grateful for the incredible legal minds, especially Rob from Law and Lumber, who has been super supportive and sending a lot of his people over here to watch trial during the day. He has a recap that's tonight. We've redirected our live stream. As soon as this one ends, we'll redirect to his channel. So if you haven't made that jump before, just sit there tight as soon as it ends. When the screen goes black at the very end and the music stopped, wait a few seconds. There'll be a pop-up that will invite you to jump over to his channel. You can click the like button as soon as you get there and be notified as soon as he goes live. But he's going to be covering that, and I'm sure he's going to have a lot to say about what happened today. So I look forward to having that legal analysis from him. And I think, is he going to have Spidey on tonight? Is that what I heard, or is that going to be another day? We might have a behavioral analyst on as well with Law and Lumber. So that is fantastic. All right. Anything else? I don't think there's anything else that we have to talk about. I think we're good. We've gone there. We've covered everything. You guys have been fantastic. We get a little bit of a break before Law and Lumber tonight. I will see. Hopefully I'll be able to pop in a little bit. I do have a date with Mrs. R.A., so I cannot commit to be there very long, but I'll try to pop in and wave and listen in just for a little bit. That's our Ivy Bowen says, thanks, R.A., for all. Even if I feel you've been a bit biased today. Ivy, I was a bit biased. I apologize. I will try to do better. I will try. I make no promises. I will try. But Ivy, thank you very much. I appreciate your opinion. I appreciate when you have a dissenting opinion because you're able to share it very effectively, and I appreciate that being here. That's always welcome. Gray Adam Nusky says, thank you for the stream today, R.A. Bye all. Oven Mitt. Thank you. Oven Mitt is one of our custom emojis. He's pointing out the fact that he's gray. We'll get you in green here soon enough, Adam. We'll get you back. Tonight, when you go home, everyone, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. By my clock, it shows 8:30 in the morning is our start time. And then trial starts at 8:45 with the lawyers in court, probably doing a little bit of paperwork. And then tomorrow, we've got Jennifer McCain. We've got Mr. Shad, who's a pharmacist. We have a billing and coding expert. We have a depo from Mr. Hanna. We have a depo from the Guardian ad litem. All on the deck for tomorrow. It's going to be spicy. We are nearing the end of this trial. Time is getting tight. It's getting very, very tight. So it's going to be awesome. Thank you all. Have a great night. Be good to each other. Whimsical Drew, I saw that message. That's good news. We'll see you guys. Have a good one. Bye.